Thank you very much, Tina. Good morning, Council. I'll call this meeting of the Standing Committee on City Finance and Services of January 20th, 2021 to order. This meeting will be convened by electronic means as authorized under the order of the Minister of Public Safety and Solicitor General of the Province of British Columbia. Emergency Program Act, updated Ministerial Order number M192. As such, committee members are participating by phone, and as chair of this meeting, I am also participating by phone. Please note if my connection is lost during any portion of this meeting, we will recess the meeting until my connection is restored. If committee members lose connection during the voting process, we have staff on hand to facilitate getting you back online quickly while we suspend the voting process. The contact information has been circulated to you. Committee members are also reminded that we need to ensure there is quorum during the meeting, so please make sure your video is on. The live stream of this meeting will have both audio and video. Video of committee members speaking, presentations, amendments, and vote results will be projected to viewers when available. We acknowledge that we are on the unceded territories of the Musqueam, Squamish, and Tsleil-Waututh nations. We thank them for having cared for this land and look forward to working with them in partnership as we continued to build this great city together. I also want to take a moment to recognize the immense contributions of the City of Vancouver's staff who work hard every day to help make our city an incredible place to live, work, and play. Clerk, may we have the roll call, please?
Yes, Mayor Stewart.
Here.
Councillor Carr.
Here.
Councillor DiGenova.
Present.
Councillor Fry.
Here.
Councillor Swanson. Councillor Swanson.
Here.
Councillor Hardwick.
Present.
Councillor Wiebe has a leave of absence for civic business between 9:30 and 1:30 today. Councillor Boyle.
Present.
Councillor Dominato. Councillor Dominato. And Councillor Bly is in the chair. Councillor Kirby-Yung.
Present.
The meeting has quorum, Chair Bly.
Thank you very much. So before we start committee business, I'd like to go over the plan for the day. Following the updated guidance issued on December 4th, 2020 and extended on January 7th, 2021, in-person participation for local government meetings and public hearings is not permitted under the Provincial Health Officer Order on Gatherings and Events. Therefore, speakers who will be providing comments to council will be by phone, and a moderator will assist in patching the speakers through when their turn comes up. Speakers should follow along on Twitter at VanCityClerk for updates on the progress of the meeting so that they don't miss their turn to speak. Any comments on agenda items can be sent to council using the web form on the city's website. The link to that form will be tweeted out on at VanCityClerk. We have 5 items of business on today's agenda. We have 3 reports and 2 members' motions that were referred from December 10th, 2020. We will begin with consent items that have no speakers. If the business does not complete before noon today, we will recess for lunch at noon, followed by an in-camera at 1 p.m., and we will reconvene in committee at 4 p.m. A reminder that when presentations are being streamed, the public live feed has a slight delay. As chair for this committee, I'm suggesting for reports that have no speakers, presentations, or consideration items, we adopt the recommendations collectively in a single motion. There are no speakers for items 1, 2, and 3. Does any member wish to hold any of these items for debate or questions to staff? And I see Councillor Carr is on the queue, so I will advance you, Councillor Carr.
Yes, could you hold item 1, please?
Item 1 will be held. And nobody else on the queue, so I will take that as 2 and 3 to be moved forward. Does any member wish to declare a conflict of interest on any of the consent items? And that would be for report number 2 and 3. Okay, seeing nobody, we need a motion to adopt the recommendations contained in items 2 and 3.
So moved,
So moved.
Councillor Dominato.
Councillor Dominato, and we do not need a seconder as we're in committee. All those in favor say yay.
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 All those opposed say nay. So the following has been approved on consent. Agenda item 2, contract award for general excavated materials, sorting, loading, and hauling. And agenda item 3, contract award for PS 202000434, provision of a sewage and rainwater management plan for Vancouver. We will now consider reports with presentation speakers or that have been held for debate. Before we begin, I'd like to remind speakers that they have 5 minutes to make their comments, should state whether they are in support or in opposition of the recommendations. However, we don't actually have speakers for this report, so I'm going to move on. So the first item is the Code of Conduct for Council members and Advisory Board members. Jason Toit, Assistant Director, Civil Litigation, along with Legal Services staff, are on the line to answer questions. Mr. Toit, are you on the line?
I am, yes. Can you hear me okay?
We can hear you.
Thanks. And Chair Blythe, it's Paul Mokry here, Acting City Manager. Good morning, Mayor Kennedy and Council. I was just going to provide a couple of opening comments and then turn it over to Jason to walk Council through a more detailed presentation regarding the recommendations. But if I may, just very quickly, this report and draft bylaw that you're receiving today is being provided in response to Council direction in October of 2019 to review the current Code of Conduct policy at the city. We very much welcome that direction and the opportunity to come back to you today with these recommendations. Just to clarify the scope, so right now the city has a policy that's been approved by Council that sets out a Code of Conduct. That policy covers councillors, Council-appointed advisory board members, and staff. The draft bylaw and the recommendations that Mr. Toit will be walking you through today relate to a recommended bylaw that staff are putting forward that would apply to councillors and council-appointed advisory board members. We have over a number of years, for the past 5 years that I've been engaged with this, encountered really significant challenges in the application of the current policy in relation to complaints pertaining to members of council in particular. There's a process set out in the current policy that is very difficult and in many cases has been functionally unworkable. I think from my perspective, what the staff have done, our staff team, is develop an approach for the city for dealing with such matters that is much closer, I think reflects best practice from other municipalities, will work much better for council, for the public as well. With respect to staff, staff are, as I said, covered by the current Code of Conduct policy. That would remain the case. So there is a council-approved policy. That policy will continue to apply to staff. I know there's been some concern that staff would not be covered by any Code of Conduct. That's not the case at all. Staff will continue to be covered by the policy that's in effect today. The process for investigation of complaints under that policy in respect of staff is quite straightforward. It's like any other allegation of a breach of policy, any other policy that the city has. We have very well-established processes for investigating those and administering sanctions where those are relevant. So we've not encountered any difficulty with the current policy in respect of application to staff. It is something that we are going to review, and any changes would be subject to council approval as well. So just to clarify, staff will continue to be covered by the current policy and the processes set out in that policy. What you're considering today, council, is a recommended bylaw that would apply to members of council and advisory board. So with that, I will turn it over to Jason to present an overview of the bylaw, recommended bylaw, and the rationale for the changes that we're proposing. Thank you.
Thank you very much, Jason. Over to you.
Thank you. Good morning, Mayor and Council. So I have with me Andrew Aguilar. He's a lawyer with the law department as well, and we together have been working on this matter of revamping the Code of Conduct. The council report that you have before you recommends a new Code of Conduct bylaw along with some ancillary recommendations that facilitate that. And today we've got a presentation for you that will review the research that we've undertaken with respect to the Code of Conduct, which has ultimately resulted in the recommendations for this proposed bylaw. And we will also review the operation of the proposed bylaw and walk you through that. So I'm first going to hand it over to Mr. Aguilar, and he can begin the presentation. Should have a slide deck.
And are we going to have the slide deck start now, if we could?
Yes, just waiting for it to come up on the live feed.
Thank you.
Okay, I do see it up there, so you're free to go ahead.
Thank you. And if we could just go to the first slide. Mayor and Council, thank you. We're happy to appear before you today to provide the results of our review in response to this Council resolution from October 1st of 2019. The resolution essentially requested that staff review the current Code of Conduct and provide recommendations for improvement. Staff were directed to look at best practice and ethics regimes generally, and specifically ethics regimes implemented in other jurisdictions in Canada, and to look at the issue specifically of reimbursement of legal fees in relation to Code of Conduct complaints. If I could get the next slide, please. Staff undertook this review in 4 phases. The first phase was essentially to conduct research. The second was to review the Code of Conduct in light of that research. The third was to identify recommendations for improvement. And the fourth was to prepare the administrative report and draft bylaw, which are before you today. You get the next slide, please. Looking at the research, looking at the research of best practices, it's important to note that British Columbia is one of the only provinces that does not require municipalities to have a code of conduct for elected officials or to mandate certain contents of that policy. The issue of enabling legislation for both a code of conduct and for the establishment of an integrity commissioner was initially raised by the Union of British Columbia Municipalities in 2016, but rather than make a request that the province bring forward such legislation, it was sent back for more study. In response to that, a working group was convened, and that was the Working Group on Responsible Conduct with members of the Union of British Columbia Municipalities, Local Government Management Association, and the province. So the literature and studies that came out of that working group, where we started our research in this case, there was a 2017 report and a 2018 Model Code of Conduct. The Model Code of Conduct itself wasn't in significant depth, but some of the recommendations from the report have helped motivate and support the recommendations we're making before you today. Staff also reviewed other municipalities, particularly Toronto, Montreal, Winnipeg, Saskatoon, Regina, and Surrey, considering various elements, including the provincial legislation, specific bylaws, and in particular, the third-party ethics officers and how that was set up. Staff identified best practices and tracked the adoption of these practices across municipalities and across the various codes, noting in particular that the codes and the wording of the codes in Toronto and Calgary were particularly strong and have helped form the code before us. Next slide, please. Looking particularly at the gaps and problems as the city manager alluded to, we acknowledge one of the first ones is that the code did not acknowledge the difference in concerns relating to conduct of elected officials and those of staff members. One important difference in the city of Vancouver is that staff are subject to numerous city policies, including the respectful workplace policy and the human rights harassment policy, which do not apply directly to council officials. The code of conduct was more of a one-stop shop for the ethical obligations of councillors. The code of conduct, we noted, was outdated, passed originally in 2018 with the last update in 2011. There were no express provisions for education or advice or informal dispute resolution processes, and no provisions for regular review, which were all areas that were brought up in the Working Group on Responsible Conduct. There weren't some safeguards for abuse. There was no discretion whether it automatically proceeded to formal investigations. There was nothing to check overlap with other legislation, and no controls regarding complaints during election periods. And as alluded to again, it was a cumbersome and unwieldy investigation process for councillors, particularly that consent of both the complainant and the respondent was needed to appoint an investigator. Next slide, please. So staff has prepared 9 recommendations. I think in preparing these recommendations, staff also kept in mind the purpose of a code of conduct or ethical code of conduct. And one of the key purposes that council members are keepers of the public trust and must uphold the highest standards of ethical behavior in order to build and inspire the public's trust and confidence in local government. And we think these recommendations, which are in accordance with best practice, help address those. The first is that their staff create a new and separate code of conduct for councillors and advisory board members. Essentially, that rather than revise the current code, staff recommended that we draft a whole new code, and that the review of whether there are any changes required or a new code for staff will follow. Looking at the second was to retain an independent third party on a set term with a mandate for education, advice, and investigation. Here, the independence promotes trust and facilitates many of the other recommendations, and advice and education being key components to ensure that to prevent breaches in the future. The third was to minimize the overlap between the new code and other applicable legislation. This is again a best practice to ensure things such as that we don't impede more appropriate processes or allow text cases or contradictory findings or multiple complaints across different processes. The fourth was to provide a mechanism for preliminary vetting before determining whether to proceed with a formal resolution, and having an independent third party integrity commissioner assist with this. The fifth was to include informal dispute resolution procedures. The current code requires that complaints automatically go to formal investigation. They don't allow for any type of mediation, even if the parties requested it. The sixth was to revise the current procedure for dispute resolution with the final decision made by council. Here, the intent is to have an independent, transparent process with council making a final decision in public. In all municipalities reviewed, other than Montreal, where there is a provincial agency, council has always been the final decision maker in regards to the code of conduct. The seventh is to establish a process for the public release of investigation reports to increase transparency. The eighth is to include provisions for reimbursement of legal expenses for council members. That was in accordance with the resolution from council. And the final is to set a procedure for regular review of code against recommended by the Working Group on Responsible Conduct. Thank you, and I'll turn it over to Jason.
Jason, you may be
Sorry.
on mute.
I was on mute. Thank you, Andrew. Next slide, please. So, Council, now I'd like to turn toward the proposed bylaw and provide an overview of the bylaw and describe how it addresses all of the 9 key recommendations that Andrew just mentioned. So we've drafted a new code of conduct bylaw. It's attached as Appendix A to the council report. It does address all of those 9 key recommendations. And as we've noted, one of those recommendations is that the bylaw only apply to council members and advisory board members. That's because it recognizes a best practice that we see across Canada in almost all jurisdictions, separate codes of conduct between employees on the one hand and council members and advisory board members on the other hand, and really recognizes just the different roles they play and the different considerations that go into the conduct that's expected of them. So the bylaw, as the city manager noted in his opening, does not apply to city employees. However, the code of conduct policy that's currently in place will continue to apply with city employees, and we are looking at updating that and reviewing the employee code of conduct, and we hope to be before council later this year dealing with some recommendations with respect to a code of conduct that applies to employees. Next slide. So the key provisions of the bylaw, in terms of an overview, we have a standards and values section that sort of sets out those values that members are expected to uphold. They involve competence, fairness, integrity, leadership, respect, responsibility, and transparency. And we've endeavored, in comparison to the current code of conduct policy, we've endeavored to try to make these values more concrete so that they actually describe the actual conduct that's expected with respect to each of these values. We have a section on communications and confidentiality that relates to communication, public communication by members, and also the handling and protection of confidential information. And we have a broad section that deals with various conflicts of interest, such as using municipal assets and services, the use of influence, election activities, and covering the receipt of gifts or personal benefits. Next slide. So one of the key recommendations is to retain an independent third party who we've called an integrity commissioner. This is really critical and core to the entire ethics regime that we're proposing be set up. It's because what we end up with, or what we're seeking to have, is an independent person who will have a mandate for education, advice, and investigation. Under the current policy, we simply, on an ad hoc basis, when a complaint comes in, we hire an investigator to review that complaint. We're looking for a much more comprehensive regime with an independent person dealing with that regime. So in terms of the independence, we have an appointment process provided for in the bylaw. It requires a 2/3 majority of council to appoint the integrity commissioner. It's for a set term of 2 years, and that's in order to provide some level of independence. And the integrity commissioner can only be terminated for cause, and that termination also requires a 2/3 majority of council. There are some provisions for an ad hoc appointment of an integrity commissioner simply for investigations in those circumstances in which an integrity commissioner may not yet have been appointed. The duties and responsibilities, really the key aspects are advice, education, and the investigation role. An ethics regime requires the ability to educate those individuals, in this case, council members and advisory board members, on their obligations. So that integrity commissioner will provide an educational role to ensure that members understand their obligations under the code, and also play a role in educating the city staff and the public as to members' obligations and the role of the integrity commissioner. And second, it will provide a process whereby members can seek advice and recommendations from the integrity commissioner when ethical issues arise. So there's oftentimes that there's gray areas, and in our view, it would be appropriate and supportive in an ethical regime to have members have a person they can go to seek advice on those ethical issues. And then the final role is the enforcement or investigation role of the integrity commissioner to deal with complaints that arise under the bylaw. Other aspects, the integrity commissioner would be required to submit an annual budget for approval by council, and they would also publish an annual report that would summarize their work and provide any advice or recommendations that they may have for improvements to the code. And that aspect addresses one of our other recommendations, which is that there be a regular review of the code, so that the code is continually getting improved based upon the experiences of its operation with the integrity commissioner. Just very briefly, in terms of what we're envisioning for the integrity commissioner, we're not looking at setting up an office in the city with employees and staff for an integrity commissioner. We're looking at an integrity commissioner that would likely be a lawyer retained by contract that would perform the duties and responsibilities of the integrity commissioner as needed. Next slide, please. The proposed bylaw will minimize the overlap with applicable legislation. Again, we see best practices across Canada and in the academic literature that indicates it's not appropriate to duplicate processes. It runs the risk of forum shopping. It runs the risk of people trying test cases in different forums and contradictory decisions that may arise in different forums. So we're attempting to have a code that doesn't deal with matters that are already addressed in other legislation. So, for example, this code does not apply to conduct that may subject a member to disqualification under the Vancouver Charter. There's certain conduct relating to conflicts of interest where a member has a pecuniary interest that can result in their disqualification. So by way of example, how this would work under the current bylaw is if we take an example of the Vancouver Charter that provides that members must disclose gifts received that exceed $250, and their failure to do that can result in their disqualification from holding office. If under this proposed bylaw, a complaint was received by the integrity commissioner alleging that a member had received a gift in excess of $250 and had not reported that gift, the integrity commissioner would receive that complaint, review it, see that it involves an allegation that could result in disqualification under the Vancouver Charter, and the integrity commissioner would reject that complaint as being outside the jurisdiction of the code and would advise the complainant the reason for that rejection, being that there is another process provided for under the Vancouver Charter for addressing allegations of that nature of misconduct that can result in disqualification. The Vancouver Charter provides a fulsome process with respect to that, with respect to disqualification of councillors. And that involves bringing a petition. 10 electors of the city can bring a petition to BC Supreme Court seeking a declaration that that member is disqualified. So that process provides ample procedural fairness, ample natural justice, and ample opportunity for a council member, the respondent in this case, to respond and provide full answer and defense to those allegations. So a very fulsome process, alternative process that we don't need to duplicate under the Code of Conduct. We've also provided in the bylaw that the Integrity Commissioner must reject any complaint that would more appropriately be addressed through another process. So complaints in the nature of, for example, a human rights complaint. There's, again, a more fulsome provincial tribunal set up under legislation that can address those matters, and there's no need for the bylaw to duplicate that and attempt to address them in another form. Next slide, please. We've revamped the complaint and resolution process. We've created a process which we call confidential request process, and that is to address concerns that some people may not wish to come forward and present a formal complaint. And so we've tried to create a process which will allow someone to remain confidential. Their identity will remain anonymous. No formal complaint is filed. But in that process, the only thing that the Integrity Commissioner will do will take that confidential request and attempt to informally address the conduct with a member, but it will not result in any investigation. It will not result in any findings being made, and it will not result in any sanctions being imposed, and it will not trigger a formal investigation. If the person who makes the confidential request is not satisfied with that process and the outcome, they can then decide to proceed with a formal complaint process, and that has a much fulsome review process, which I'll get into next. Next slide, please. So this is a very quick overview of the complaint process. You'll see that a written complaint is received by the Integrity Commissioner. The Integrity Commissioner then does an initial assessment. That initial assessment can result in it being rejected or closed. Or if it passes the criteria, it can then, the Integrity Commissioner then considers whether it ought to go to informal resolution. If it is appropriate for informal resolution in the Integrity Commissioner's view, then it will go off to an informal resolution process. If it's resolved through that process, the complaint is closed. If it's not resolved through the informal process, or if the Integrity Commissioner had initially decided that it wasn't appropriate for that process, then the Integrity Commissioner will conduct a formal investigation and ultimately issue an investigation report. Next slide, please. So in a bit more detail, the complaint procedure, we do have certain criteria that are the requirements for a complaint in writing, naming the complainant respondent, alleging the specific conduct, etc. And the Integrity Commissioner does have the discretion to still proceed with a complaint if all of those requirements are not necessarily met. Next slide. So another recommendation we had was that there be a mechanism for the preliminary vetting of complaints. So we've provided in the bylaw several criteria that the Integrity Commissioner must look at and must reject a complaint if certain criteria is not met. We've set a limitation period of 180 days, and that runs from the date the complainant knew or should have known of alleged conduct. It can be rejected if it's outside the jurisdiction of the code. It can be rejected if the complaint is filed during what we've called the blackout period. So essentially from the last day of the nomination period to the general voting day, we've created a blackout period where complaints can't be filed. If the complaint's determined to be frivolous, vexatious, not made in good faith, if the complaint would not be in the public interest to investigate, if there's a lack of cooperation by the complainant or a non-compliant complaint, it can be rejected. And if there are ultimately insufficient grounds to support the allegation of a breach, then the integrity commissioner can determine that complaint ought to be rejected. Next slide, please. Another recommendation we had was that there ought to be an informal resolution process. Our current code doesn't have that, and it requires a formal investigation in every case for a complaint. So we're now contemplating a process whereby the integrity commissioner gets that complaint. Once it's determined that it's an appropriate complaint, can assess whether that complaint has the prospect and it's appropriate to be resolved informally. If so, the integrity commissioner can attempt to resolve that complaint directly with the parties. The integrity commissioner also has the option, if it's a complaint by a member against another member, to refer that to the mayor to attempt to resolve, and the mayor has the ability to engage a third party to assist with that process. Similarly, if the integrity commissioner believes that the city manager would be well placed to attempt to resolve that complaint involving a complaint by either a staff member or the public against a member, the integrity commissioner can refer that to the city manager to attempt to resolve. And also, we've tried to provide some flexibility for the integrity commissioner to really tailor an informal resolution process to the parties and the nature of the complaint. So the integrity commissioner is empowered to consider other mediation processes, other culturally appropriate, transformative, or restorative justice approaches, and may engage a third party to assist in that respect. If the informal resolution is unsuccessful, then that matter is automatically referred and goes into the formal investigation process. Next slide, please. So in terms of the formal resolution process, we've tried to make a much more robust process that clearly sets out what that process is. So we have provisions relating to the service of the complaint on the respondent. We've set out expressly the integrity commissioner can speak to relevant witnesses and request documents. The integrity commissioner is entitled to access any city record except a record that's privileged. We've expressly provided that the investigation must comply with the rules of procedural fairness and natural justice. And we've also provided that the integrity commissioner must make reasonable efforts to conduct that investigation in confidence. We've also attempted to make sure that the formal investigation process isn't subject to undue delay and that it will result in timely determinations of complaints. And so we've set a timeline for an investigation to be completed within 90 days. We've recognized that there may be situations in which an integrity commissioner has a particularly complex matter, and the integrity commissioner can extend that timeline for 30-day periods, but has to provide notice to the respondent and the complainant of those extensions. Next slide, please. We've recommended that there be a public release of investigation reports, and that really enhances the transparency of the entire process. So if the integrity commissioner determines that there's been no breach of the code of conduct, the integrity commissioner is required to prepare a written report. That written report must contain the reasons for that determination, and the report will be issued to the complainant, the respondent, and counsel with public release 48 hours after that. If the integrity commissioner determines that the code has in fact been breached, again, must prepare a written report setting out the reasons for that determination, must make recommendations as to appropriate sanctions, and must deliver the confidential report first to the respondent, and 48 hours after delivery of the report to the respondent, must deliver the report to the complainant and counsel, and then after ensuring that the report has been delivered to complainant and counsel, must make the report available to the public. Next slide, please. We've provided in the bylaw that council will make the ultimate determination as to the appropriate sanctions that are to be imposed on a council member who's found to be in breach of the code of conduct. We've again set some timelines to ensure that it proceeds in a timely manner. So council must make that determination within 30 days of receipt of the report. They can pass a resolution to extend that. Prior to making the determination, again, in the interest of procedural fairness and natural justice, we require that the respondent be provided an opportunity to make representations to council, either in writing or in person, to put forward their views of the decision and also to put forward their views on any recommended sanctions. And finally, council must deliberate and vote on that report in a public meeting. Next slide, please. We've set out the sanctions, some of the sanctions that can be included and considered by the Integrity Commissioner and Council. Important to recognize that Council doesn't have the legal authority to remove or suspend a councillor from office. So some of the sanctions that Council can impose are necessarily limited, but we do include such matters as a letter of reprimand, publication of a letter of reprimand, and a request for an apology by the Integrity Commissioner along with the response by the member, requesting a letter of apology from the member, suspension and removal of the appointment from the member as deputy mayor, or suspension or removal from council committees or any other bodies that member might have been appointed to by council. With respect to advisory board members, of course, council can terminate the advisory board member's appointment to the committee or task force or board that they are a member of. And finally, council, of course, has the ability to publicly censure a member. Next slide, please. There are just a couple of miscellaneous provisions that we did want to highlight. Where there's an investigation that happens to overlap with a municipal election and the councillor that's the subject of that investigation is not re-elected, then we provided that the Integrity Commissioner must close the complaint. And the reason for that is that the Integrity Commissioner will lose jurisdiction once the individual who's subject to the complaint is no longer a council member. We've provided that the Integrity Commissioner cannot open multiple investigations on the same subject, that they have to proceed with the first complaint that they receive. However, they may expand a complaint to deal with additional issues or add additional complainants. As well, we've provided that the Integrity Commissioner has the discretion to accept the withdrawal of a complaint. Next slide. Now, staff were expressly asked by council to address and look at the issue of reimbursement of legal expenses. We've reviewed that issue. The Vancouver Charter does not permit council by bylaw to indemnify for claims other than damages claims. So it's not possible in this bylaw to include a provision that covers all situations and says councillors are entitled to reimbursement in all matters. But what council does have the power to do under the Vancouver Charter is to pass individual resolutions for the reimbursement of legal fees. So we've provided in the bylaw, we've acknowledged that that authority, and we provided in the bylaw that council can, in accordance with the Vancouver Charter, pass a resolution to reimburse legal fees in appropriate circumstances to a council member who's the subject of a complaint. And that is the end of the presentation, council. So we're certainly happy to accept to answer any questions you may have.
Thank you very much to staff. That is a tremendous amount of work. Let's go over. We do have councillors on the queue for questions. So we will start with Councillor Swanson. Go ahead, Swanson, for 5 minutes. And just check you're not on mute, Councillor Swanson.
Sorry, can you hear me now?
Yes, we can hear you. Go ahead.
Okay. I just wanted to confirm that staff will still be covered by the old code of conduct.
Yes, they will continue to be covered by the current code of conduct policy that we have.
Okay, thanks. And then I had one question about the appendix that has all the rules in it. 2A, 2D, I think it is, says that the councillors have to act in the best interests of the city as a whole. And I'm wondering if that could be interpreted that if you do something for one part of the city or one group of the city, you're not acting for city as a whole. And if that part should just be taken out and saying that you shouldn't act, so that it says that you shouldn't act in your own personal interest.
I think certainly we see that language through multiple codes across Canada. I think the presumption is that while councillors may have different views as to what is best for the city, that councillors, when they're acting as councillors and performing their elected duties, their ultimate goal is to pass policies and processes which are in the best interest of the city. Whether that involves, it may involve a particular constituent group, but it's premised and presumed on the basis that the view of that councillor is this is what is needed for the betterment of the entire city.
Councillor Thompson, may I interrupt? Could you move your mic so that you can speak more directly into it, and then that's better audio live stream. Thank you.
Sorry. Is that better?
Yes, it's great.
Okay. Yeah. So my concern is just with the interpretation of best interest in the city. It seems like that could be interpreted in a whole number of different ways. It's not a firm thing that you can say, well, I'm doing this or I'm not doing that. But
Is there a question, Councillor Swanson?
no, that's okay. Go ahead.
Okay.
That's it.
Thank you. Thank you very much. Next on the queue is Councillor Carr. For 5 minutes, go ahead, Councillor Carr.
Great, thank you so much. Yeah, I did send these questions in, but I just wanted to put them on the public record to get the responses if that's okay. Thank you for writing some responses to me. So the first question I have is around the Appendix A page, which is on page 8, section 4.6, where councillors must not contact contractors or service providers. I was a bit concerned about that. First of all, will the Integrity Commissioner be a contractor?
Yes, that's what we envision the role. It'll be, as I indicated, a lawyer on retainer contracted to the city.
And it would be normal that councillors should contact the Integrity Commissioner if they've got concerns and want to avoid problems, et cetera. Would that not be the case?
Absolutely. In fact, the bylaw expressly provides that that's one of the roles and responsibilities of the Integrity Commissioner, is to provide, for example, advice and recommendations to councillors when they request that.
Excellent. Okay, well, because I don't want to see that there is a conflict within the bylaw, i.e. the Integrity Commissioner, that we should seek out advice. On the other hand, there is a section of the bylaw that says we should not contact contractors. I will be submitting an amendment that just makes that perfectly clear. So, yeah, so just heads up on that. In terms of other service providers, you know, there are other, I mean, can you give me some sense of what those service providers are? I'm assuming many of our housing providers and nonprofits that run the housing on city land, these are contracted service providers, are they not?
Yes, there'll be a myriad of service providers throughout the city, like you say, and it could be in social housing, it could be construction crews, building buildings or building roads. Many different types of contractors at the city.
Right.
So,
okay. I just again have concerns that there are times when it makes sense for a councillor to ask a question or to have a conversation even around a particular situation with a service provider. You know, it's probably not with the vast majority, but there's some areas that that are, I think, more in the public profiles that would make sense. So again, in my amendment, I'll just address that to try and, you know, not open the gates to this, but make it clear that there are opportunities. This is not a cut and dry, never can contact a service provider or contractor, but rather just recognize that there are appropriate opportunities or reasons why that should happen. So I have forwarded the language to you, so when we get time to move the motion, I'll bring it up then. So thank you for those answers. And my final question is if the Integrity Commissioner receives, and thank you for including what happens when a complaint is received and it falls under the charter in terms of the severity of the possible outcome being disqualification from office for the councillor. So if the Integrity Commissioner receives a complaint and determines that it does fall under the charter with the potential for disqualification from office, what does the Integrity Commissioner actually do at that point? Do they simply advise the complainant to take a petition to the Supreme Court and there's no attempt at any kind of, you know, potential informal resolution or anything else? It just explain to me what you envision happening under those circumstances.
Yeah, certainly. What I would expect to happen would be that the Integrity Commissioner would receive that complaint, would determine that there's another appropriate process, being the Vancouver Charter, would recognize that the bylaw excludes the Integrity Commissioner from investigating matters that could eventually result in disqualification of a member, and would therefore advise the complainant that there is another process, it's under the Vancouver Charter, and if they wish to pursue that complaint and allegation, that they ought to proceed with that process and that it won't be considered under the Code of Conduct.
Okay, so that kind of a complaint would only, the resolution would have to be found through the complainant taking a petition to the Supreme Court of BC.
Yeah, and there's I mean, I've mentioned earlier in the presentation sort of the reasons, not to have the overlap, but one of the other considerations with respect to
And just
the
10 seconds for your answer.
Vancouver Charter is there's a 45-day limitation period under the Charter. We have a 90-day investigation period. That time would expire before the report would even be issued.
Got it.
Perfect timing. Thank you very much. Next up, we have Councillor Hardwick. For 5 minutes, go ahead, Councillor Hardwick.
Thank you very much, and thank you for this work. I'm encouraged as I saw the current policy as being substantially flawed. So I'm supportive of the direction that this is going, but I have a number of areas of concern that I'd like to discuss on the public record. So I'm going to start, but I may be coming back for another round of questions, just being upfront about that. My first question is going back to the subject of staff. Under the current policy, if there is a complaint made against elected officials or committee members, it goes through an investigator process. If there's a complaint made to staff, it was pushed up to adjudication through the city manager and HR. As my examination of the existing policy, that doesn't say what happens with the city manager. How can the city manager adjudicate himself or herself, for example? So first question, with respect to the city manager and others, corporate leadership, senior staff who are appointed by council, that are politically approved appointments, and that would include the director of planning, the director of finance, as well as the city manager and others. How would this new policy deal with those use cases?
So the current Code of Conduct policy, my understanding is what has occurred in the past is if there were complaints or allegations made with respect to a city manager, that likely the director of HR would look at those complaints and advise council of those complaints, so that council would be aware of those complaints, and that a process would be worked through there whereby council would be kept informed as to the nature of the complaint and what steps were being taken with respect to that complaint.
Okay, that seems weak to me, and so I would suggest that in these senior positions that have great public profile, that might be something.
Because this is questions rather than debate. So if you can just stick with questions.
All right, then is it possible then to include these senior roles in consideration of this new bylaw?
Sorry, just to clarify, are you asking whether or not we could include the employees like a city manager and those senior roles within this current bylaw?
Yes.
It would be highly unusual to include staff within this bylaw because there would be other considerations with staff that don't arise with councillors. So there are many other provisions that we would want to apply to those staff, such as political activity, those types of considerations that we would, expect to find in a staff code of conduct. There are also other considerations in terms of employee-employer relationships and legislation that deals with those issues. So they're really of a different beast, if you will, than elected officials.
I understand that for rank and file staff, I'm singling out these specific roles, and I'd like to have a further discussion about that. But moving on, I was pleased to see that there would be some notification and transparency that when code of conduct complaints were dismissed, that information would be made public, because that's not the case now, and has required, my knowledge has required FOIs. This brings me to the question about when a code of conduct complaint is made and is made publicly. What are the ramifications for that in terms of apologies on the other side? So if a code of conduct complaint is made against a councillor, it is dismissed, and it may have been spurious, it may have been slanderous and libelous. What are the implications or recourse for the councillor or committee member that's been on the receiving end of the complaint?
Certainly. Unfortunately, council, clearly doesn't have the authority to take any action against a member of the public who might make a complaint that is ultimately unfounded. However, council, I should say, the individual council member that might be subject to that complaint may have some private law remedies, but this code doesn't have any provision. They can potentially recover their.
I'm asking right now for another round of questions before my 5 minutes.
Okay, we are at 5:04.
Now, I got it in before the 5.
Okay, you got it in just at the second. So is that a motion to?
Yes, it's a motion to have a further round of questions.
Okay, and so we'll take that to a vote. All those in favor?
Aye.
Yay.
Aye. Any opposed? Okay, great. So we'll have a second now. Thank you very much, Councillor Hardwick. So next up, we have Mayor Stewart for 5 minutes.
Great.
Oh, there we go.
Yep, thanks so much. Right, I'll save my comments for the comment round. A couple of questions. So you have eliminated, for example, the ability of the Integrity Commissioner to recommend that council go to court to seek a petition to disqualify a councillor for whatever reason, or a member of council, and citing that that's already covered through another process. But what happens in the course of an investigation if the Integrity Commissioner finds something for which a councillor could be disqualified for, or mayor? What does the Integrity Commissioner do then?
Well, we're not proposing the Integrity Commissioner proceed with complaints that aren't before the Integrity Commissioner. So we're not proposing the Integrity Commissioner expand complaints based upon investigations, that they conduct an investigation on the complaint that's been put forward. So in a circumstance in which the complaint expressly alleges something that would result in disqualification, as I've noted, the Integrity Commissioner would decline that complaint. If through the course of the investigation, the Integrity Commissioner may have learned something that might suggest that something had occurred, that's not the subject of their complaint. So they won't be addressing that in their.
Well, it could be related though. It could be through the course of reviewing emails or talking to other folks that the Integrity Commissioner goes, holy crap, there's something really bad here. What happens in that case? They seem, by the way this is written, don't have the option of recommending to council that disqualification be pursued.
There is no express provision in the code for the Integrity Commissioner to recommend disqualification.
Right. And so I do get the so I just wanted to be clear on that one. What could you just walk through what a public censure looks like? Because that seems to be the kind of highest level of sanction that council could administer in this case.
Certainly. So a public censure would be a very public process. It would involve council sitting, raising the allegations and the conduct that have occurred. It would involve a fulsome process of having the council member that's subject to that censure having a full opportunity to respond and present their case, if you will, as to why the public censure ought not to be made. and it would be a formal resolution of council publicly censuring an individual for certain conduct, and obviously would have a significant profile because it would be reported widely, and it's really a tool that all legislative bodies have to show the fact that they're not happy with the conduct of one of their members. Okay,
thanks. Another question, I guess, related to the first one is, will council, so a complaint comes forward, the integrity commissioner looks at it and says, oh, that should be handled by the court and, the petition and the 10 signatures. Is council advised of that complaint, or is that just kind of disappear?
Certainly the respondent is. Andrew, can you assist me on this one?
I think the one thing that I guess in setting up the code is that it's a complaints-based process where the integrity commissioner is to respond to the complaints. It is somewhat limited in the scope of not ensuring that the integrity commissioner is an investigator with unlimited range to investigate and find new complaints and disclose them. The integrity commissioner can include, I think, facts in either notices if they're closing the complaint, or include if they're either going to find a complaint or dismiss a complaint in the investigation report. They could, in that report, allude to findings that they've made. So I think it would be open to the integrity commissioner through those publicly released documents to address them. But the integrity commissioner has not been given power within this code to start new investigations or to conduct investigations of their own accord as if they were a police service or something like that.
Oh, sure. But if a complaint comes and it's reviewed by the integrity commissioner and the integrity commissioner says that needs to go through the court process, we're never alerted to, and essentially dismisses that.
5 minutes. So I'm not sure you'll get a question at this point, Mayor.
Okay, sure. Yep, I can wait till the next round.
Thank you. So next up we have Councilor Dominato for 5 minutes.
Thanks, Chair, and thank you, staff, for the work on this. I'm really pleased to see this come forward. I think it's a really important body of work. A couple of questions. I'm looking for some clarification around section 5.1 and 5.6 of the draft bylaws. And just if you could clarify for me that in passing these bylaws and appointing or moving forward with integrity commissioner, would the intent be that council would move forward as a next step and appoint an integrity commissioner that would be available to council for the next 2 years, and in the event that there are items that need to be addressed, or is it appointing an integrity commissioner as and when needed? So can you just clarify sort of the intent here? Does that question make sense?
Yes, I think I understand the question. So the intent is that there would be a permanent integrity commissioner appointed on a 2-year term. And that individual would be available to council to perform their obligations, their duties and responsibilities under the code. So we wouldn't have a revolving door of different integrity commissioners. It would be one integrity commissioner for that 2-year term.
Okay, so basically they'd be on retainer for 2 years until such time that, okay. And so then the section in term of ad hoc appointment 5.6, can you walk me through that and the role of, it has the mayor can appoint an ad hoc integrity commissioner, the city manager can appoint one. What does that mean in layman's terms?
Certainly. So we've tried to contemplate a circumstance in which it may be that matters arise and either council haven't yet appointed integrity commissioner, or it may be that it's in between terms of integrity commissioner, so we don't have a permanent one in place. Perhaps the integrity commissioner has resigned or withdrawn. So it's attempted to deal with those situations in which we don't have an integrity commissioner when a complaint comes in. And so that would involve someone being retained on an ad hoc basis just to deal with a specific complaint. And we've provided that with respect to a complaint by a member against another member, the mayor would be the one who would appoint that ad hoc integrity commissioner. or maybe preferably we call them investigator. Or if it's a complaint made by the public or a staff member against a member, then that integrity commissioner or ad hoc investigator would be appointed by the city manager, but solely for that investigation process.
Okay, and is there a rationale for, in the case of the permanent appointment of an integrity commissioner on retainer, it's would be done by a council, 2/3 vote of council members, that in the case of an interim ad hoc appointment, we wouldn't be bringing that to council and doing the same?
Simply for the speed to ensure that we have an investigator that can be appointed quickly to address the complaint. That's really to make it a simple process. It's going to be, like I say, a one-off investigator, not unlike what we do under the current code of conduct policy now, except it won't require consent of the parties. It'll be one individual, the mayor or the city manager, making that determination.
Okay, so from your perspective, it's for administrative purposes, it's to sort of streamline things in the event, but hopefully, ideally, we would have an integrity commissioner retained on a regular basis.
That's certainly the intention.
Intent. Okay. I just want to move along because I have some more questions. Section 4.6, it was already brought up by Councillor Carr, specifically around communication with service providers, contractors. Would you have objection or concerns around an amendment to that would remove the word contact? I personally have some concerns that in our roles, we are regularly dealing with service providers, nonprofits, agencies in our role to act on behalf of the public, and recognize the need to not be giving direction per se, and particularly around contractors and so on. But I do think it fetters our ability to represent the public adequately, and I would propose that amendment if it was seen to be reasonable.
Certainly, we, with respect to that provision, we pulled that out of the current code of conduct policy. That's currently in the policy. We weren't aware that there was an issue with respect to that, but certainly in terms of if there's a legitimate purpose for councillors contacting contractors, not directing, but contacting, we wouldn't have any opposition to that.
Thank you, I appreciate that. And then I just want to circle back on as well the subject of communications, sections 3.1 through 3.4 of the draft bylaw. And just to address what I see as a bit of a challenge, maybe you can elaborate on it. It reflects that council members can't communicate on behalf of the city unless they're authorized to do so by council resolution or by virtue of a position or role that they've been authorized to undertake by council.
We're just at 5 minutes, perhaps you could go back on the queue to answer.
Yeah, I'll go back on the queue. Thank you.
Thank you. Next, we have Councillor Swanson. Councillor Swanson, you do have 2 minutes left, so I'll keep track of your time as it was reset automatically in the Crestron.
Yeah, this is about section 3.4. So the question is, how do we ensure that discriminate, harass, and defame aren't used to silence political opponents? Sorry. For example, I got called out for saying that Landlord BC is a lobby group. So is that defaming them? I got called out for using the word class. I got called out for using the word gentrification. So if I tweet and use those words, am I violating this section? I'm really afraid here that this is going to be limiting our political position and our...
Your question, Councillor Swanson.
Pardon?
I just think we should allow staff to answer your question directly.
Okay.
So, Councillor Swanson, I can't speak to specific instances or examples, but I can say that the Integrity Commissioner, we've empowered the Integrity Commissioner to have that preliminary vetting process to determine, what are frivolous complaints, for example. And it's a fairly robust process, and it will be for the Integrity Commissioner to sort of map out and determine, what conduct falls within the code, or what conduct ought to be, complaint ought to be closed on the basis that, for example, it's frivolous or vexatious.
If I could just add one quick comment, the line we're attempting to draw, and I think the basis for which we've taken these provisions, is what's called respectful free speech. So notifying and the central issue being free speech, but drawing the line simply that it's respectful. And I think that's why the original subsection as well says, without limiting the ability of a council member to hold a position on an issue. So it does, the purpose of this is to acknowledge that ability to have free speech, just to do so in a manner that facilitates further discussion, and that Integrity Commissioner can provide advice and further guidance on that going forward.
Thank you very much. And that's the 2 minutes. Councillor Hardwick, we are still in our first round. So if you wouldn't mind going back on the queue, Councillor Kirby-Yung has not had a round of questions yet.
Okay, but if
second
I
round.
put myself down, then I go under Councillor Dominato. Is there a way I can be moved under Councillor Kirby-Yung?
I'll check with the clerk, but right now you are under Councillor Dominato. Oh, there we go. You're sorted out there.
Great,
Oh,
thank you.
Councillor Kirby-Yung, please go ahead.
Yeah, thank you very much. I just want to sort of pick up on this line of questioning because I'm seeing a number of amendments that I anticipate coming forward, and they do relate to this notion, this balance between the responsibilities of councillors holding and council members holding the office and the notion of free speech. And I'm seeing amendments that come forward to sort of the ability to protect that. And I wonder if you can speak, two-part question. One, in terms of what the code covers relative to sort of the Charter of Rights and Freedoms and sort of different governing legislation with respect to the free speech, but also can you speak to the responsibility, and this is the specific part of my question, around council members to stay on the side of free and open debate versus fanning the flames, and I think this is a very pertinent question for things that have happened in Vancouver and given what we've seen happen in the US right now, and fanning the flames on tough and critical issues that result in potentially personal or negative hate speech being targeted to certain councillors as opposed to focusing on issues. And I'm choosing my words carefully here because I've seen this happen in this council, and I think it's troublesome when it crosses the line between bringing voices forward and targeting individuals for personal characteristics. So can you speak to how it's covered either in the this code or other mechanisms, and where council's responsibilities lie on that, please?
Certainly, as Andrew mentioned, we've tried to walk the line to allow, obviously, legitimate political debate, which is going to occur and ought to occur, but that there be respectful communication. We've also tried to contemplate that there is a difference in terms of speech or communication that a member may make in their personal life as opposed to in their official role. So we've tried to deal with comments that might be made, conduct in the personal life versus their professional life.
Maybe I could be a bit more explicit in the question, and I'm sort of asking in the sense of if a councillor's behavior fans the flames and encourages others to bring forward or sort of mobilize feedback from the public that is not focused on an issue, but is focused on targeting other individual members of council. I want to be very clear about that.
I would just jump in and say that I think there's a lot of very difficult issues here and a lot of difficult gray area. And what we've attempted to do is provide some guidance and discretion, but the Integrity Commissioner is the one who's going to have to be making specific determinations, I think, factually in each of these cases. And so the line that's been drawn in the Code of Conduct is the general concept of respectfulness, which I think is one that Calgary has adopted and Toronto has adopted, and ensuring, and the minimum standard being that it does not defame or harass and those types of things. But for all of the various gradients in between, I think the attempt of this code has been to give the Integrity Commissioner the ability to address those as they come up, considering all the facts and trying to balance the interests of council.
So we'll still have situations potentially where that individual will have to navigate through those circumstances and provide appropriate direction back.
Yes, the Integrity Commissioner can provide advice, though, and education, hopefully, to help set some boundaries for that discussion.
Okay. And following up on one of the earlier questions, it's been raised by a couple of councillors with respect to 4.6. And I'm wondering if it's as simple as, because right now the language reads in this amendment, this relates to contracting, contractors, tenders, consultants, other service providers. It says contact, instructor, direct. I'm wondering from a staff's perspective if the simple removal of contact, but leaving instruct or direct would retain the sort of intention of this clause, but still enable dialogue or sort of information provision to happen between councillors and these various.
Yes, certainly. Removing it's primarily the instruct and direct that we would be most concerned about. is ensuring that those provisions remain as part of the code.
Right, and that's what I was wanting to highlight for the record. It's that the concern really is that council doesn't direct the work that's done by staff. Our role is setting policy and direction, but it's the communication piece, I think, that is troublesome. So if a simple amendment was made to that effect, that would still maintain, that would address staff's concerns. Is that fair to say?
Yes, I think that's fair to say.
Okay, thanks. I'll leave it there for the moment. Thank you.
Thanks, Councillor Kirby-Yung. Next, we have Councillor DiGenova for 5 minutes for the first round, and then Councillor Hardwick and Dominato.
Thanks very much. I want to really thank staff for coming back with this. I know that this was part of the resolution from a motion that I moved back in October of 2019, but I've seen some flaws in the process for a long time. In fact, one of my questions stems around one of the flaws that's currently in the process, which would allow someone not to agree to an investigator and indefinitely put off an investigation. Is that a current flaw in the process that's addressed through these changes that staff are proposing?
Yes, certainly. As you've noted, the previous process under the policy was cumbersome, difficult, and required the consent of the parties to agree on an investigator. Now, with an integrity commissioner that's been appointed by council, that individual will be in place to address and deal with all complaints.
Okay, thank you very much. My next question is in regards to specifically the appointment of an investigator. There still is an investigator involved in a portion of the code of conduct, the proposed changes. Is that correct?
Well, the integrity commissioner also plays the role of investigator. So the integrity commissioner conducts the investigations of complaints. There will be a separate investigator.
So no political, or I should say, no elected official, including the mayor, would have any power to appoint an investigator without the consent of those involved. It would be the integrity commissioner, correct?
Only in circumstances in which there is not an integrity commissioner appointed. So if you're in between terms, for example, and a complaint comes in and we need to have an investigator and we don't have an integrity commissioner, then there's provisions for the ad hoc appointment of an investigator, and as I indicated earlier, by either the city manager or the mayor, depending on the type of complaint. But provision that in most cases we'll have an integrity commissioner who will be conducting those investigations.
Thanks.
But the new provisions don't require consent of both parties.
Okay, and that's what I was getting at, and I think just as our mayor did here, I'll give an example. And when we consider this, we have to consider it not only for this council, but I look at this for councils in the future, just as the council that considered the code of conduct that we currently have did. So my question is, do you see that being problematic? Not specifically speaking to any individual on council or this mayor, because I also understand if it involves the mayor, it could be the deputy mayor that chooses I suppose, the investigator, but with no agreement or no agreement in options. Is there any concern about sort of the crossover there with an investigator being chosen by a political office?
Someone has to be able to appoint the investigator. We've looked at it administratively in terms of how could we do that in a manner that would be quick, without delay, and have that investigation proceed. We also, are of the view that a lawyer that's appointed has certain professional obligations, and we'd expect that investigator to have their professional obligations and perform their role objectively when investigating a complaint.
Okay, thanks very much. Also just wondered, could you give me a figure on the outside investigators right now under our current code of conduct? In the past year, how much has the city spent on outside investigators?
I can get that figure for you. I don't have it handy, Councillor DiGenova, but
Thank you.
I can get that.
And then another piece is in the city of Vancouver code of conduct specifically for staff that was mentioned that would be continued. And I may need another round and we can continue this on then. But it specifically states that there under 8.13 consequences associated with breaches of the code of conduct. But I also understand that there are consequences if it's seen that there's a motivation other than to rectify one of the matters of the code of conduct broken, and someone brings a complaint. So that there could be ramifications for that. Are there any ramifications for anyone who files a complaint for reasons that the integrity commissioner finds later on are political or not specifically pertaining to that complaint if their motive is different?
The answer
Maybe you could answer that afterwards. I'll go back on the list. Thanks so much.
Great, thanks very much. Next, we have Councillor Hardwick for a second round of questions up to 5 minutes.
Thank you very much. Would FOI apply to the integrity commissioner?
Yes, the city doesn't have any ability. The privacy legislation expressly states that no public body can exempt themselves from privacy legislation, so it would apply to, and then the standard exemptions would apply to specific elements, such as protections for ongoing investigations.
So again, as stated in the presentation, if the outcome of an investigation would be transparently, that report would be made public. So I gather it wouldn't require FOI. Would this be applied retroactively?
No, we haven't indicated, we haven't provided for the fact of releasing, I assume you're referring to releasing previous reports?
That's correct, where there have been code of conduct complaints levied and dismissed, but that information has not been transparently reported to the public, as you were suggesting will be the case if this passes.
Yeah, so we haven't provided for that retroactively. And I think one of the concerns would be that the parties who engaged in the process under the code of conduct policy would have an expectation, or at least would have a policy which provided that that would be held, would be confidential.
Again, one of the inherent flaws in the existing system. I'd like to go back to the question. You had a section in your presentation called standards and values, and this has been touched on in terms of freedom of speech. I have an overarching concern about the values police. It's important that we not muzzle dissension. So how do you differentiate? I mean, obviously ad hominem attacks are going to be a clear violation, but there is some subjectivity in terms of freedom of speech and ideology coming into this. How there's a nuance and subjectivity to values. How do you address that?
What we've attempted to do in the standards and values section is to set out broad values, but with concrete sort of explanations of the conduct that addresses those values. It will be impossible to create a code that you can look at and provides an answer to every ethical gray issue, every communication or comment. It's simply not possible to do that. Reasonable people disagree, obviously, but we've attempted to make it as concrete as we can by, for example, using language that you can't engage in abuse, bullying, or intimidation. Now, reasonable people may disagree as to what intimidation is, but that's why we have an independent integrity commissioner who will assess those issues.
Okay, because we're living in a day and age where you hear things like silence is violence and microaggressions and all of this, which is extremely subjective. And so I'm concerned that that this be handled delicately. Again, ad hominem attacks, bullying, those things are really clear, but there's a lot of gray area here. So I'm just looking for further assurances that the value side of things won't be weaponized. Any further comment?
I don't think I can state any further on that, Councillor Hardwick.
Thank you.
Okay, thanks, Councillor Hardwick. Next up, we have Councillor Dominato for a second round of questions. 5 minutes, and your timer starts now.
Thanks, Chair. And just following up on the presentation around the focus or recommendation of having a regular review of the code of conduct, I think that's really important. But my question is this, is it implied because there isn't a specific time frame articulated in the bylaws around council will undertake a, an annual review or biannual review of the code of conduct that that's implied that because the integrity commissioner would be reporting out annually and making recommendations around areas of improvement, that it would be an annual review of the code of conduct? Is that a fair interpretation?
Certainly that's the intent, is that council will have the information if the integrity commissioner has recommendations to improve the code, and they can act on that if they so wish.
Okay. Okay, thank you. And then circling back to the question I'd started around the draft bylaw, communications confidentiality. Appreciate the focus on both these areas. I'm trying to wrestle with, and here's the question: is sections 3.1 through 3.4 around council members not authorized to communicate unless by council resolution, or authorized because maybe they hold a certain role, whether that be a mayor or they're the chair of a committee or something like that. When in fact we have to communicate on a regular basis on behalf of council to some degree, and it may or may not be, captured in resolution, but through a council resolution. And so I'm struggling a little bit with some of the articulation of this, and I'm just wondering, is this did we draw this language from examples of other codes of conduct from other jurisdictions? So how did we come to this?
Andrew, can you respond on the issue of where we drew that language from?
Thank you. I'm just taking this language is drawn from the bylaw in Calgary. So it's been interpreted, I think, through some of the guidance that they had in Calgary. And the idea being, I
can't hear.
Yeah, sorry, point of privilege. We're having trouble hearing.
Thanks very much. If the staff responding could speak into their microphone a little closer, that'd be great.
Chair, can you reset my timer by about 15 seconds, please?
Yes. So staff responding, can we just get a quick audio check?
I'll step in here. I believe what Mr. Aguilar had indicated was that that language was drawn from Calgary's code. We're attempting to obviously draw the line in terms of individual councillors, when they make statements, ought not to be speaking for the city, that they're speaking for their views on matters. Now, Councillor Dominato, there may be circumstances in which there may be situations in which a councillor may, in fact, speak on behalf of the city, and we're certainly open to looking at exploring that if that needs to be revised in some way. But the intent was just to provide that councillors generally are speaking for themselves, not for the city.
Okay, thank you. Yeah, it's a bit nuanced. I have one more question I just want to get your perspective on, is how do we handle in future where we've had active public policy campaigns that are launched, in some cases maybe driven by particular parties, but the unintended consequences of those campaigns, those types of communications, is that they target specific councillors and their families. And the unintended consequence of that is that they end up with threats and they have to deal with that. And it's another piece I'm wrestling with in terms of communication, because of course we're entitled to our opinions. We can represent ourselves and our views, but we've had this slippery slope, and we've seen that over the course of the last year, where a campaign around an important public policy conversation was happening, but because councillors were named, the unintended consequences is their families received threats. And would that be something the integrity commissioner could look at?
I'm assuming you're referring to threats that are being made from outside the city in terms of not other members or staff.
Yes.
Yeah, so the Code of Conduct bylaw doesn't address that, and the Integrity Commissioner would have no ability or authority to address threats that are made outside by the public to council members.
Okay, thank you. That's it for me, Chair.
Thanks very much, Councillor. Up next, we have Councillor DiGenova for the second round of questions. And
Thanks so much. I just was hoping to have that last question that I tried to slip in answered. I wasn't sure if staff had perhaps were prepared to answer that.
Great. Let's go ahead, staff.
Sorry, I was just going to ask what if you could remind me of that question again, Councillor DiGenova.
Okay, I think I was just finishing the question, and it was specifically in looking at the consequences piece, and that there would be some ramifications for staff. That I think it's specifically in the code of conduct policy for staff that if the motive was other than the specifics of their complaint, but it was to in some way harm or hurt. Or bring negative attention to another person, that there would be ramifications and consequences for that. I'm just wondering if this code of conduct offers that same ability to the integrity commissioner. For instance, if someone was to, there's slippery slope between democracy and being able to have open and transparent government in some ways. We want people to be able to obviously feel that they can come and make a complaint and be transparent about it. But if that complaint is actually has a political motive, my concern is there's no consequences attached to that as there are to other policies. So I was hoping that perhaps staff could comment on that.
The bylaw does not provide for any sanctions to be imposed against a complainant.
Could I jump in, Jason?
Sure.
Just one note, though. Under preliminary assessment, it is specifically contemplated that the Integrity Commissioner both reviews a complaint initially and has the ability to continually review throughout the investigation. One of the grounds the Integrity Commissioner can close a complaint on is if it's not in good faith. So if the Integrity Commissioner determines and it becomes clear over the course of an investigation that a complaint was made with an improper motive or clearly to attack someone for purely improper motives, the Integrity Commissioner has an ongoing ability to be able to close that complaint.
Okay. So in comparing that to current process right now, I just wondered, I hope maybe just for a short answer on this if possible. If right now our city process says that a complaint must remain confidential and the city actually engages in a contract, the investigator, if the complainant, let's say it's a counselor that a complaint is made against, and the complainant's a member of the public, and they go out to the media with the details in that confidential document afterwards, does the city bear any liability, or will the city take any action civilly, to make sure that any defamation of that individual through that confidential document is handled?
Just to clarify, Councillor DiGenova, are you referring to if the investigator's report is?
Yes.
Well, under
specifically by one of the parties in the investigation.
Under the current, under the proposed bylaw, those reports will be made public by the Integrity Commissioner, so they will be out there in the public.
Okay. And then when it comes to assault or harassment, or just as some professionals in their jobs have a duty to report things that are actually of a criminal nature to the police, I'm wondering if the Integrity Commissioner will have that. Like, for instance, if someone is physically assaulted in chambers or somewhere else, is there a duty to report to police?
We haven't included a duty by the Integrity Commissioner, though I suspect the example that you've given, if someone's assaulted in chambers, that there will be many people who will be able to report that to the police.
Would be able to, but would the city not have a duty to do that, to keep its employees, but also its officials safe?
I
Would
think
there not be some oversight?
I think you can be assured in the circumstance that you've indicated that the city would be reporting that matter to the police.
Thank you.
Thank you very much, Councillor. Up next, we have Councillor Swanson, who's second round of questions. Go ahead, Councillor Swanson, for 5 minutes.
I was just going to propose that since there's a huge slew of amendments, that we ask staff to take the amendments and what they've heard and go back and try and incorporate what they see, so we won't spend all day amending amendments.
Okay, I'm just going to pause, and I do appreciate the suggestion, but I think we're going to stick with our procedure bylaw process. And unless you have a motion to move, we're going to follow our typical amendment process and go through each one by one. So you don't have questions to staff, as I understand it?
Okay, no.
Okay, and do you have a motion?
No.
Okay. So that it actually ends our question period on this item. And so we will move us over to a main queue. And Council, is there any debate on this item?
I'd like to move the recommendations in the staff report.
Thank you, Mayor. So the item has been moved. And if you have any debate, please go in the queue. I see we've got Councillor Hardwick up first. So I'll advance you, Councillor Hardwick, for 5 minutes.
Thank you. And first of all, I would like to thank staff for their work on this. It's a very delicate and important area. Again, my experience with this policy is that the historical one that goes back to 2008 and I think was renewed in 2011 it has been fundamentally flawed and I think has had some negative consequences for current council members, including myself. So I'm grateful for this work. I'm hopeful that Integrity Commissioner, together with some of the other aspects of transparency and strengthening our democracy, will continue to move forward, including the work we've been doing on the Auditor General, but also hopeful about a lobbyist registry. Together, I think these are three things that will really strengthen trust, hopefully, within our local government and within the city. So I wanted to state my general support for the Integrity Commissioner and the work that's been done here. I think there's some fine tuning that needs to be done. There's always, the devil is in the details and how these things play out. And I do want to ensure that transparency is indeed encouraged and that the kind of attacks that I've seen these policies weaponized, and I'm very concerned that these issues be dealt with proper impartiality. So I'm hopeful about the Integrity Commissioner, and I just wanted to state on the record my support broadly, but hopefully we'll see some refinements to the bylaw and address some of the public concerns, particularly about staff, because what we've heard over and over again in the feedback that we have been receiving from our residents is a concern that by moving ahead with this bylaw governing elected representatives and committee appointments, that staff would not be included. So I think that those listening can be assured that staff are not getting a get out of jail free card, so to speak, if there's concerns there, but rather this is going to be dealt with in a more systematic way. So again, thanks to staff for your work on this, and I am cautiously optimistic that this is heading in the right direction. Thank you.
Thank you, Councillor Hardwick. We have up next Mayor Stewart.
Thanks so much for all this work, staff. I have to say that the existing code is just a nightmare to oversee. It's very underspecified. You're kind of guessing. It's also quite stressful because potentially have somebody's career in the balance and definitely it's tough enough being a politician, and having a a code that doesn't work isn't what we need here. So really commend the staff for doing a great job. And although my role is much reduced in this new code, I'm really happy for it. I think future mayors will be too. It's just such a strange position to be in. I do have 2 amendments that I've sent to the clerk, and I'm hoping they're not too controversial. The first is that I did enjoy the access to a federal and ethics commissioner, where we could ask for advice all the time, and that was really helpful. So if you have a gift or something, or those types of things around disclosure, you can always ask questions. What I noticed about this version of the code, it was a little bit restricted in what we could ask advice on, because not only do we have to worry about the charter, there are some other provincial acts under which we have to disclose, and it would be useful if we could ask the integrity commissioner questions about those disclosures too. So that is the first amendment that I have, that slightly broadens the advice that we can ask for from the integrity commissioner. The second one, so that would be 5.9, that would be slightly amended. And I have checked these as well. The second input from the legal team. E is that I did earlier on in the term, we were talking about tightening up the making the our city code consistent with the conflict of interest members conflict of interest act that's provincial, and I thought this is actually much better for the integrity commissioner to do this themselves rather than me suggesting changes, so that we would assign this to the integrity commissioner if we decide to go through with this, which I hope we do. That part of their first report would be to try to make the members conflict of interest act and our own code a little bit more consistent, and give them the time they need to do that. So that those are the amendments I'm moving. Just
Mayor, if I may just ask for clarification, you're moving these amendments together as one?
Yes.
Okay, and so I'm going to move us over to an amendment Q at this point. Okay, and then if you'd like to continue your comments, please go on the queue. Otherwise, I'll open it up for debate.
No, I'm good. I'm happy just to have these considered, and I hope I've provided enough explanation as to why I think they're necessary.
Okay, great. So I just want to give councillors a moment to read through the amendments, and also put yourself on the queue if you'd like to add any comment or debate to the amendment itself.
I'm good.
Okay, not seeing any councillors on the queue, we can go to a vote. I'll ask the clerk to pull up the voting panel. Now, bear with me, council. I need to figure out where I place my vote.
You have to do vote assist yourself.
Oh, okay. I am voting in favor. Thank you, clerks, and thank you, Mayor. So that is unanimous in support for the amendment, so that amendment passes.
Thanks, Council.
So we'll go back to the main queue. And let me just, next we have Councillor Swanson on the queue.
Can you hear me? Oh, maybe Councillor Dominato was supposed to be first.
Yes, Councillor Dominato, so we were on the previous queue. So back to the main queue, we have Councillor Dominato up next for debate.
Thanks, Chair. I'm sorry, I'm just sending the amendment in now. I thought I had and I didn't. It is with respect to my comments earlier about including striking the word contact in section 4.6 of the draft bylaw, simply to reflect the discussion we had earlier with staff. And so it's really about not instructing or directing contractors and tenders and consultants. And so I think it's self-explanatory. I'll pause there.
Okay, great. So I'll take us over to stop your timer and take us over to an amendment queue. And I'm going to clear the queue and advance Councillor Carr for 5 minutes. Councillor Carr, you are on mute.
Yeah, that should be fine.
Okay.
Is that good?
Go ahead. Mm-hmm.
So I had raised this actually as this section as an issue, especially around contacting, and did raise it in questioning at the beginning of considering this item on the agenda. So I had submitted an amendment, but I found that after I'd spoken, Councillor Dominato just put forward a much more elegant solution, which is to remove the word contact, which staff appeared to say was fine. More elegant, so I'm withdrawing the amendment that I circulated, just so all of you know, with councillors, and we'll be supporting this amendment. I think it's incredibly important to put that in there for two reasons. One is, of course, the Integrity Commissioner, him or herself, should be contacted, and that's kind of an obvious disconnect in my mind that we would have two different directions under a bylaw, and secondly, because there are specific contractors. I'm thinking especially around the housing contractors and the degree to which that file in particular is, I think, extremely important, and we pursue each of us as councillors that we may want to contact a service provider regarding. So I'm happy to see this, as I say, very simple correction or change to the proposed bylaw and fully support it.
Thanks, Councillor Carr. I just have a question to the mover of the amendment. Are you certain that this has been sent into the clerk? Because as I understand, they do not have your amendment at this time.
Yes, Madam Chair, I sent it through the council meeting amendments.
Okay, thank you for clarifying. I think, yes, okay, we do have it now. So we'll just wait for it to come up on screen. And then we'll be moving to Councillor Fry for debate.
Oh, sorry, was that my cue to speak, Chair?
Not quite yet. I think we should just allow our clerks to get the amendment up on screen to ensure that they have the right amendment and we're speaking to the same language. Okay, I see it there. So Councillor Fry, please go ahead for 5 minutes.
Yeah, and I certainly won't take 5 minutes. I do appreciate this amendment and generally supportive. I routinely have contact with folks who are sort of in our contract realm, in particular around the downtown east side and service provisions, and they variously receive grants and stuff from the city. So I'm very supportive of the intent, but out of an abundance of caution and due diligence, Chair, I'm wondering if through you we could ask of Mr. Twa if this still supports the intention of the code of conduct bylaw and doesn't get in the way.
Yes, that would be fine. So Mr. Twa, could you please comment on Councillor Fry's point of information?
Yes, I think that still captures the intention. As I indicated, that provision was sort of a holdover from the previous policy. So I think that's that still captures, which is really the we're trying to avoid instructing and directing of those contractors.
Fantastic. Absolutely understand and appreciate that. And I will wholeheartedly and enthusiastically support this amendment. Thank you, Chair.
Thank you, Councillor Fry. Councillor DiGenova, you are next on the queue for 5 minutes.
Thanks very much. I think that it's really important that we consider how this is going to.
Councillor DiGenova, you are cutting in and out, so we're not registering what you're saying.
Appreciate Councillor Domnato's amendment because my internet connection.
Yeah, I think it is your internet connection. Perhaps you'd like to call in, or we can see. Do you want to try it?
Said my internet connection is perfect.
Oh, okay. Well, try again.
So it shouldn't be an issue. I will. Perhaps you could restart my timer. I just wanted to note that I really appreciate Councillor Domino bringing this forward. I think that when I was looking at contact and I think about contractors, when we think about other outside agencies and boards, contractors too. So I was going to have questions around the Vancouver Economic Commission, Vancouver Public Library, who we could and couldn't contact, including contractors who work on city bids and projects, but are also coming with applications and during a certain period of time can approach us. So I feel that this has now been addressed. I think that there's still some other wrinkles that will need to be worked out in this, but appreciate Councillor Dominato really thoughtfully considering this and explaining it, and I will be supporting.
Thank you very much, Councillor DiGenova. Seeing no one else on the queue, we can go to a vote. And I will be voting in favor, Clerk. And that passes with unanimous support. Thank you, Council. We'll go back to our main queue, where Councillor Dominato, you have the floor is still yours if you'd like to continue to comment.
No, I'll continue comments after we've done amendments. I see quite a few coming up. Thanks.
Great. Next, we have Councillor Swanson. Go ahead, Councillor Swanson. Your timer starts. Yeah.
Yeah, I have 3 amendments. I sent in 4, but I'm only going to submit 3. One is to 3.4 about freedom of speech. One is to 2F about civil disobedience. And one is to 3.1.
Okay. Shall I move us to an amendment queue? And just to clarify, you're removing all 3 amendments as one amendment?
It could be separate. I think it'd be better if they were separate.
So we'll just start with the first one, Councillor Swanson.
Okay, 3.4.
Okay, so I'm going to move us to an amendment queue and just clear the queue.
I'm just waiting for it to come up here.
Yes. We'll just give the clerks just a minute to pull it up,
Okay.
Councillor Swanson. And before we move to the queue, Councillor Swanson, is there any, would you like to introduce your amendment with more detail before we move to the?
Yeah, this is just to make sure that councillors' freedom of speech isn't interrupted by what is written now. So it would say to ensure that all communications don't discriminate, harass, or defame, but add in giving primacy to the importance of free and open debate as guaranteed under the Charter of Rights and Freedoms, so that we can't be basically silenced for being political.
Okay, thank you. I see it up on the screen, and we do have councillors on the queue to for discussion. So I will advance Councillor Carr for up to 5 minutes. Councillor Carr, just double check you're not muted. We're not hearing you, so you're still showing as muted.
Hear me now?
Yes,
You hear
we
me
can
now?
hear.
Yes. Okay. I'm not sure why we keep being muted on the WebEx, but it's awkward to have to keep going back there. I'm not sure why that is being done, Madam Chair. This is just a point of procedure, or maybe personal privilege. Maybe we could have an explanation at some point.
Councillor Carr, yeah, I would advise that over the lunch break, perhaps one of our IT could support you in solving that. I had the same issue yesterday, and it was helpful to get IT support.
Okay, thank you very much. Madam Chair, I do have an amendment to this amendment. So perhaps you want to move us to Amendment 2Q?
Yes, I will do so. And let's just give the clerks a chance to bring that up on the screen. Councillor Carr, maybe you could start to introduce your amendment to the amendment while they're bringing it up.
Sure, be happy to do that, Madam Chair. So I appreciate the importance of bringing up the issue of the need for to support always free and open debate guaranteed under the Charter of Rights and Freedoms. However, I do take exception to the removal of the word respectful, and I am in disagreement with giving primacy to that, the importance of free and open debate. And I'm going to give you my reasons. In terms of giving primacy to the importance of free and open debate, my amendment removes those and just said recognizing that free and open debate is guaranteed under the Charter of Rights and Freedoms. I have witnessed too many people who stand on the freedom of speech and Charter of Rights and Freedoms platform to be racist, homophobic, misogynist. And I'm sorry, but I believe that there has to be respectful debate, and then it's not just all about the primacy of free and open debate. So that's why I made that change. And secondly, in terms of the word respectful, I don't know how many of you listened this morning. I did to the inaugural speech by President Joe Biden, and it certainly brought me to tears, recognizing how important his message was in terms of being respectful and people coming together. So I think respectful debate in a civil society, in a real democracy, is extremely important, and I do not want to see that word lost.
Thank you, Councillor Carr. We do have councillors on the queue. I will advance Councillor Kirby-Young next for discussion up to 5 minutes.
Yeah, thank you. I appreciate Councillor Carr you bringing this amendment forward, because I was on the queue to ask a question of Councillor Swanson as to why she had struck the language "demonstrate disrespect towards any person," and I was really concerned to see that because I'm very supportive of free speech, but I also believe fundamentally that as elected officials and as leaders, there is an expectation that we set the tone, and we should not only adhere to a standard, we should actually exemplify a standard of civil and constructive discourse. And to see phrases like that removed and chipped away, I think does tremendous disservice to the environment that we should be creating. It has been toxic and divisive at all levels of politics, both I think in our civic level here municipally in the past year, and we've seen it play out on a much larger stage. I also had the opportunity to watch the inauguration this morning, and I think those themes of trying to get people to a place where they can actually hear each other and have conversations is fundamentally important. So I was deeply dismayed to see the language struck. And again, I'll say it, and it was, as in here, it was, quote, "demonstrate disrespect towards any person." So I'm equally grateful to Councillor Carr for including that language here, because if we are not setting the tone, then who is? So I would wholeheartedly support this amendment. Thank you.
Thank you, Councillor. Next, Councillor Dominato for up to 5 minutes for discussion.
Thanks, Madam Chair, and I'm very pleased to support Councillor Carr in this amendment. I was also reflecting on when I was reviewing the amendments, the removal of respectful consideration and debate, and And I'm actually feeling relieved that Councillor Carr brought that forward, because I really do think that needs to be reflected in the code of conduct. And as we're talking about communication, obviously freedom of expression and speech is critically important and something we must uphold in our country. But I do agree, we've seen freedom of expression used, as Councillor Carr pointed out, to express racism, misogyny, and you know, I didn't get a chance to watch the inauguration this morning. I was shuffling my kids to school, but I did listen intently to President Biden's acceptance speech in the fall, and he reflected on how we really need to leave behind the harsh rhetoric and to stop treating our opponents as enemies. And I think part of that is respect. And I really appreciate Councillor Kirby-Yung reflecting about setting the tone. And so I'm happy to support the amendment to the amendment here and to retain that language around respect, and but also still that consideration about our rights and freedoms under the Charter, which is also important as well. And so I think you've struck that balance, Councillor Carr, so thank you.
Thank you, Councillor Dominato. Seeing no one else in the queue, we'll move to a vote on the amendment to the amendment. And that passes unanimously. Thank you, Council. So we'll go back to the amended amendment. And Councillor Carr, you still have the floor.
Yeah, I'm fine, Madam Chair.
Thank you. Next, we have Councillor Kirby-Yung to the amended amendment.
I'm fine. I think we dealt with it in the previous queue. Thank you.
Okay, so we will go to a vote, seeing no one else on the queue, to vote on the amended amendment. And go ahead, your voting screen is up.
Madam Chair, can we see the language on screen, please? The
Yeah.
language.
Yes, absolutely. Ask the clerks to put up the amended amendment language that we are voting on.
It is the clerk here, Chair Bly. We're just getting that ready to put up.
Thank you. Okay, so the language for the amendment is now on the screen and on the live feed. So we will move to the vote. And Mayor Stewart, Councilor DiGenova.
I'm still reading the amended.
Okay, great, thank you. And I am also in favor, so that amended amendment passes unanimously. Thank you, Council. So we'll go back to the main queue. And Councilor Swanson, you still have the floor.
So the next one is 3.1, the one that Councillor Dominato brought up. I just think we should delete it. This is the one where it says that you have to have a motion passed by council in order to speak about what council wants. I heard Councillor Fry on the early edition the other day, and they asked him, what is council doing about Strathcona Park? And he told them, but there was no motion passed, and people are always asking me, what is council doing about X? And so you tell them, and there's no motion passed. you try to be as honest as you can, but I think this would really restrict counselors from, as it's written, it would restrict counselors from answering a lot of questions that we are asked by constituents and by the media.
Okay, thank you very much, Watson. I will move us over to Amendment Q1 for the second amendment of yours, and ask councillors to please go on the queue if you have discussion. And I see Councillor Carr. Councillor Carr, I'll advance you first. Go ahead for up to 5 minutes.
Yes, thanks, Madam Chair. Can you hear me?
Yes, we can hear you. Thank
Great.
you.
Madam Chair, I wonder if I can ask a point of information through you to staff.
Please go ahead.
Yes. So I am questioning what on behalf of the city that phrase means to staff, whether a council member can still communicate on their own behalf or even on their party's behalf, but that's not considered to be on behalf of the city. I need clarification on that phrase, on behalf of the city.
Okay, thank you. So I'll ask staff to clarify that particular phrase on behalf of the city. Please go ahead.
Sorry, just to clarify, you're asking what we mean by the phrase on behalf of the city?
Correct.
That's correct.
So I think that what we're referring to there is that you're speaking on behalf of the city as a corporate entity, expressing what the city's position or view is on a matter as the actual corporate entity of the city.
Andrew here. I note that section 3.4 specifically contemplates that council members can speak about council motions and things before council in their own personal capacity, and that when they do so, all they need to do is ensure the communications accurately reflect the facts of the decisions, that when they talk about business, that it's accurate, and that they clarify that they're speaking on behalf of themselves, not on behalf of council. So our understanding is that the provisions as drafted allow council the flexibility to both comment and discuss them. The restrictions are just simply when speaking on behalf of council as a whole, or on behalf of the city.
Great. Okay, thank you. I really appreciate that explanation. It is the interpretation that I held when I read this. Perhaps we can have some follow-up communications from staff that just clarify the definition of what it means to speak on behalf of the city. I think that would be appreciated. But given that my interpretation is shared by staff, and I think there should be a clear distinction between speaking on your own behalf or speaking about what council has done in terms of making decisions. There's all the freedom in the world to do that, but speaking on behalf of the city is a very formal role and obligation. So I'm happy to leave the language as is and will not support the amendment.
Thank you, Councillor Carr. Over to Councillor Kirby-Young for up to 5 minutes.
Yeah, thank you very much. I was going to ask the same point of information that Councillor Carr did to clarify, because that was also my interpretation. So to be clear, for the record, I will not be supporting this amendment because I think it's quite straightforward that when you're speaking on behalf of the city, it is as the organization or officially as the entity. And that would be done by the appropriate representative, which, depending on the circumstance, could be the mayor, could be the city manager, maybe the deputy mayor of the day, speaking at an event or in response to a sort of a particular situation. And I think it is an important conversation to have to clarify that there's no limitation being put on councillors' ability to express themselves, because that in fact is a fundamental component of our job and what we do. People want to hear from us. They want to hear what our positions on issues are, and they want to have a council that's actively engaged and is extending and offering points of view. And so I appreciate the clarification that this does not fetter council in any way to do their continue to do their job and to continue to communicate publicly and robustly as an individual elected representative and an individual councillor. And I think we all do that a great deal from time to time. We all do a fair amount of media and engage with the public and have various levels of dialogue. I think what's salient here is you can express your opinions, you can discuss policy, but you can't inaccurately reflect sort of a council vote, for example. So not to be belaboring the point, but I do think sometimes it's helpful to say these things out loud. I'm trying to keep our meetings short and not add too much time to them, but I do think it's worth speaking and clarifying what my understanding expectation is, and for council to do that when it makes sense, so that we are all on the same page moving forward in how people perceive and how we comport ourselves going forward. So with all that said, I will not support the amendment for the reasons stated. Thank you.
Thank you, Councillor Kirby-Young. And finally on the list, we have Councillor Hardwick.
Thank you.
Go
I
ahead.
I'm likewise concerned about this clause. I understand why Councillor Swanson has put it forward to strike it out, and I wonder if not struck out, it couldn't be amended. I've heard staff's explanation, but it still, to me, is too loose, loose to interpretation. Speaking as a council member, if I go out and I talk about a council resolution as it's articulated here, and I will, be supportive of it or not supportive of it. If a motion passes that has taken a position that I don't concur with, I'm concerned that I would be muzzled because I'm not authorized by council to take an opposite position or a different position in public or in the media. So I just don't think that the explanation that we've received and the way that this particular clause has been articulated is sufficient to address the concerns that I have, and which I think, not to put words in her mouth, Councillor Swanson is getting at here. And the fact that we're all concerned about it leads me to the conclusion that it needs to be further defined and elaborated upon. So I'm concerned, just to say it one more time, that council, if we take a different position than has been taken by council as the whole in the majority, that we not be chastised or in other ways punished for taking a different position, and it be taken as speaking out of turn by the city. There's just too much latitude in the way that this is being expressed. So I hope we can discuss this further.
Thanks, Councillor Hardwick. Now advance Councillor Boyle for up to 5 minutes.
Thanks, Chair Bly. I just wanted to echo what some others have said. While I appreciate the sentiment and concerns, I am comfortable with staff explanation. It hasn't been my experience thus far that when I, as a councillor, disagree with a position, that I have been in any way limited in being able to express that. And I understand the importance and clarity here of when and how an individual political actor is speaking on behalf of the city, and that we have some clarity about when and how that happens. So I'm comfortable with the balance. I'm comfortable with staff's explanation of that. I'm comfortable in trusting my colleagues that will be done well. And for the most part, I think we have had a reasonable ability to disagree on decisions made publicly and not be muzzled or be called out on it. So I'm comfortable with the language as it is, having heard that explanation.
Thank you, Councillor. On the queue, we also have Mayor Stewart. Mayor, up to 5 minutes to comment. And just check that you're not on mute so we can hear you.
Thanks, sorry about that. So this is a complaints-based process that we're doing here. So, if somebody if a council member violates one of these clauses, then there has to be a complaint by somebody to the ethics commissioner, and then the ethics commissioner reviews this. We don't have too many of those anyway, and this would be probably a pretty minor one. So it's not like there's going to be some kind of proactive action by the ethics as the integrity commissioner to kind of discipline, council members that might violate something that's in this code. So I think that's important to remember. The second thing, though, is this is a very tricky area. I mean, at the police board, I am the official spokesperson, but I can't write any of my own statements. So we have committees of 7 people writing what I can say, and it's really tricky. So I would think this is be something that the integrity commissioner might, once hired, could give us some advice and training on, and just so we're all on the same page. And if we need to amend it, then that person could make recommendations for the next round. So I won't be supporting this straight through, but definitely understand the need to explore this a bit more, and perhaps best when we have an integrity commissioner secured. I think you're on mute, Chair.
Oh, I'm on mute. Councillor Dominato, you're up on the queue for, let me just reset your timer.
Thanks, Madam Chair. Just a quick question, point of information through you to staff, just around, do we have a framework around roles and responsibilities that speaks to spokespersons for the city? We had this at school board when we went through our heavy governance review and overview.
Staff?
I'm not aware of another policy or framework. The city manager may be aware. I would note that the framework in the bylaw does make the statement that a statement by a council member is actually presumed to be made on their own behalf. So that's the presumption of the bylaw, is when you're speaking, it's on your own behalf, and allows you to hold a position on an issue in the bylaw. But I'm not aware of any other policy, unless the city manager is, about spokespeople.
Okay. Thanks for clarifying that. I think that's sort of the nuanced piece of this, but I'll leave it there. Thank you.
Thank you very much, Councillor Dominato. Seeing no one else in the queue, we will go to a vote on this amendment. And that motion fails. That amendment fails with Councillors Carr, Fry, Boyle, Dominato, Mayor Stewart, and Councillor Kirby-Yung, and myself in opposition.
Madam Chair, what a privilege.
Yes, go ahead.
Screens again today, same as yesterday. I'm not seeing them coming up.
That is a good point. Let me just check with the clerk as to whether or not we can have the voting screens coming up on a regular basis on the live stream.
Thanks very much.
You're welcome.
This is the clerk here, Chair Bly. We do have it on the screen in the chamber. We did have issues last night as well with the public screen connecting to that. We're doing what we can.
Okay, appreciate that. And perhaps you can update us when IT has a solve for that. I'll take that as a yes. So we are back to the main queue. Councillor Swanson, you still have the floor.
Just one last one here to 2F.
Okay, and Councillor, I'm actually just going to move us straight over to amendment queue. You are well into your time on this main queue. I'll ask you to put yourself on the queue to introduce your amendment.
Thank you. So this is the one that says we have to comply with all the laws of every level of government, and I just wanted to add a thing on saying, except for it's okay to participate in peaceful civil disobedience.
Thank you, Councillor. I'm just checking out to see if there are any councillors who wish to comment on this particular amendment. And I do see Councillor Carr, so I'm going to advance Councillor Carr for up to 5 minutes. Go ahead.
Yeah. Thank you, Madam Chair. I will be supporting this amendment and appreciate Councillor Swanson for bringing it forward. I believe that we actually can already. I will disclose that I had asked the question of legal staff not last term, I think, but the term before, when there were protests and people getting arrested around the Kinder Morgan pipeline. And I believe our mayor may have some experience with that as well. But I was clearly told by law that it is within our rights to participate in peaceful civil disobedience. So I think clarifying that in terms of this code of conduct is important. So thank you, Councillor Swanson, for bringing it forward.
Thank you, Councillor Carl. I will advance Councillor Kirby-Yung for up to 5 minutes. Go ahead.
Yeah, thank you. I wonder if I could ask a point of information through you, Madam Chair, to legal on this one.
Please go ahead.
And I'm wondering if this is necessary, if it's already covered under the Charter of Rights and Freedoms, which would supersede a code that we have in terms of individual rights and liberties. I wonder if law can comment on that.
Yes, absolutely. So staff, over to you.
So certainly, any citizen or member of the public or councillor for that matter can choose to break the law in an act of civil disobedience. It just means that you obviously have to deal with the consequences of breaking the law in an act of civil disobedience. So, you know, I will say that, I guess how to put this is, yes, you know, any individual is obviously free to break the law and accept the consequences of that. Having the provision, the way the code is currently structured, the bylaw, I should say, would mean that if you engage in an act of civil disobedience, there's a prospect that that could result in a code complaint and investigation because you have broken the law. The outcome may be dependent upon council. Council ultimately determines the sanctions if that conduct is found to breach the code, and council doesn't have to apply any sanctions.
Okay, a follow-up point of a question to that, a point of information, if I may. The provincial code earlier that Mayor Stewart had referenced in his amendments, are you aware at this point if that speaks to civil disobedience? Because I know that we have that amendment in terms of aligning here, and I'm wondering if, I'm looking, I guess, for context and precedence to whether or not this has been covered before in members' conduct, specifically in that code.
I'm not aware of the contents of the Members Act being referenced, but I can say that we never saw this exception in any other code of conduct for, you know, municipality in Canada. We haven't seen this exception carved out.
Okay, and final point, and I really appreciate the clarification, it's very helpful. So is, when you said if a member chooses potentially to break the law, they may take that individual action at based on their judgment, and then may or may not deal with consequences of that. They break the law. So is civil disobedience itself, from law's viewpoint, perceived to be breaking the law, or is it when that civil disobedience crosses a line and becomes not peaceful, or there is some type of situation that emerges, for example, at a protest, for example?
Civil disobedience is breaking the law. In fact, that's one of the core aspects of civil disobedience, is standing up, letting people know that you are so dissatisfied with a law or government policy that you're prepared to publicly break it and face the consequences of doing that. So generally, peaceful civil disobedience is considered to be breaking a law.
Okay, thank you. And if I can comment now, then, in terms of the amendment, and based on what I'm hearing from law, I'm not comfortable necessarily at this point. This is something we should deal with in our code of conduct, because I think the notion of civil disobedience is very well defined in other legislation and in other laws, and I think it's quite different, members choosing to do so and at their individual discretion or choice, than it is, I think, having an elected body endorse civil disobedience, which is an act of breaking the law by definition, which, based on what I've heard, is affirmed by law. So I feel like that presents a conundrum for me as an elected official who, since we are in a position where we enact various legislation and bylaws and are sort of sworn to uphold them, I don't think that that precludes us from moving for change or protesting against them in many different ways. But I think that for me, that's a distinction that I'm struggling with. So I'm not sure it's something that should be embedded in this code for those reasons. That's my thoughts at this point. Thank you, Madam Chair.
Thank you, Councillor Kirby-Yung. Next, we have Councillor DiGenova for up to 5 minutes to comment.
Thanks very much. I think it was well said by a few other counselors in addressing other amendments that uh, in use of the term respectful, it didn't preclude what would be allowed in the Charter of Rights and Freedoms. And I think that it is really important to let that guide us. But what has been called peaceful protest, um, in City Hall alone and in council chambers, um, in my personal experience has also resulted in assault. So I think that unless we're going to go down the road of defining exactly what peaceful protest is, then I think uh, who is allowed to peacefully protest. For instance, I think about some of the protests that currently are going on that are a protest, and it is people who are choosing not to wear a mask and they're convening together despite the provincial health guidelines. That being said, it could be seen as a peaceful protest. It also could be seen as a risk to health for others around them. So I'm not an expert on setting the policy on this area. I'm not sure that our staff want to go down that road, or if this is framed already under the Charter of Rights and Freedoms. But for the same reasons, alongside the reasons that I've just stated that Councillor Kirby-Yung has also mentioned, I will not be supporting this amendment. I think we would have to define what that is. And in council chambers, what's been called a peaceful protest has resulted in assault.
Thanks. Thank you very much, Councillor Bujanova. Councillor Fry, up to 5 minutes. Please go ahead.
Yeah, thank you. I do support this amendment, and I'm just going to reflect on a little anecdote, and this certainly isn't to single out the mayor, but shortly after I was elected, and in a professional capacity, I was challenged by somebody who suggested that Mayor Stewart wasn't his mayor and that he was an anarchist and that he didn't trust the rules and so forth. And I was a little surprised, and when I asked him what he meant, he said, well, because he was arrested at Burnaby Mountain, and therefore he's not fit to be mayor. Now, frankly, the mayor's appearance at Burnaby Mountain inspired me, and I respect that a great deal. So I support this being explicitly referenced in this because my concern is that we may see frivolous applications under the Code of Conduct and weaponizing of this kind of thing to specifically go after councillors, or in this case, the mayor, for participating in peaceful civil disobedience, which is our right, and I think we should be allowed to engage in that. So I completely support this amendment. I appreciate the fact that it would be clearly articulated for all to see, and we could avoid the sort of frivolous and weaponization of complaints under this. Thanks.
Thank you, Councillor Fry. Councillor Hardwick, up to 5 minutes. Please go ahead.
I'm struggling with the contradictions in this amendment, because on the one hand we're saying that we must comply with our legal systems and judicial codes in Canada and the province of British Columbia, and then we're saying except for when we don't want to conform with it. If someone has a criminal record, running for office has real concerns associated with it. On the one hand, we want to be able to express where we think change has to be made. Civil disobedience has held a very important role in affecting positive change. I think back even 100 years to the suffragette movement and the movement towards women trying to obtain the ability to vote, and civil disobedience played an important role in that. But it's the balance between the two and determining how we're following our laws while we're breaking them that is the real challenge implicit, I believe, in this amendment. So I just wanted to come out and say that I know that we're dealing with specific examples in our experience in the city. You know, it's the experience of the mayor that Councillor Fry just referred to, and Councillor Swanson's own experience. We've also experienced, things happening in city council chambers that have have been disruptive and right on the edge. So it's the balance between trying to enable that peaceful civil disobedience whilst not coming out and trying to flaunt it in breaking laws. Therein lies the rub. So again, I'm wrestling with this one, and I don't think it's an open and shut case. It's going to be one of those nuanced kinds of judgments that we have to make. Thank you. Just wanted to get the 2 cents worth in there.
Chair Bly, it's the clerk here. I think you're on mute.
Apologies. Thank you very much. I am suggesting we can now go to a vote as there is no one else on the speaking queue. And that amendment passes with Councillor DiGenova and Councillor Kirby-Young in opposition. So we are right up against the noon hour, and Councillor Swanson, is it correct in that you have all of your amendments have been addressed?
Yes, they're done, thanks.
You do have 2 minutes if you'd like to use that time now to conclude your comment.
No, that's good, thanks.
Okay. So my proposal is that we actually recess for lunch now, and we will reconvene standing committee at 4 o'clock after the in-camera meeting. So if there is agreement, if somebody could move a motion to do so, that would be appreciated.
So moved.
Thank you, Councilor Hardwick. And I'll call for a vote. All those in favor?
Aye.
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 Anyone opposed? So we will pause this item and come back to it at 4 o'clock. Thank you very much, Council. We'll see you in camera at 1 o'clock and back here at 4.
Hi, David. Can you hear me now?
Yep, I can hear you now. Thanks so much.
Perfect. Okay, thank you. So I'm going to
Yep.
keep your line muted until we're ready to hear from speakers, okay?
Okay, sounds good. Thanks.
Thank you.
Thanks, Tina.
Okay, go ahead, Rowena.
Okay, so welcome back, Council. We are reconvening the standing committee meeting. And where we're at in the process is we have Councillor Carr up next on the queue for discussion to the item 1, the code of conduct for council members and advisory board members. So Councillor Carr, I'll advance you, and you have 5 minutes. Please go ahead.
Great. Thank you so much. Just to clarify, I did already say this, I believe, in one of my earlier comments, but I had forwarded several amendments, but I decided to withdraw them. One, because there was an amendment that I felt I could very much support that did the same thing as what I had intended through Councillor Dominato, which passed. And the second one, I received an explanation from staff on the process if there was going to be a potential for a councillor being disqualified from holding office. That would be under the Vancouver Charter. Staff did explain what that process would be. I feel satisfied by that. So I'll just move to final comments now. Really, we started this process recognizing that our code of conduct did really need improvement. Our acting city manager, Paul Mokry, called it unworkable. In my experience, I think that's a reasonable description. No process to informally resolve disputes, no clarity on who and how the final decisions are made, no guarantee of natural justice and fair process for the person being accused, including no established process for the public release of reports, and no provision for reimbursing legal expenses for council members or guaranteed provisions. So all of these were real gaps. These issues, every one of them, has been addressed, and I really want to thank our staff in the legal department for their hard work on this and the intelligent approach that they've brought to this, and the way they've explained it. Thank you, thank you. I really like the fact that this code separates out the current code, which will remain as the code for staff, from this code for council and appointed members of advisory committees. That makes sense to me. I really, really like the integrity commissioner and the role to educate, to advise, to avoid disputes through informally resolving them, and to investigate. I also like the focus on procedural fairness and natural justice, which to me are fundamental in any dispute resolution processes or code of conduct complaints. So that to me is a fundamental that is needed, and it's here, including the rules about the public release of documents. So the complainant to the complainant, so media do not get the reports first. So with all of those points in mind, as I say, I'm very happy to support all of the recommendations in this report.
Thank you, Councillor Carr. Next, we have Councillor Hardwick for 5 minutes for final comments.
Well, thank you. Chair, I'm just wondering, I have a question. Can I factor a question in somehow at this point?
You can ask a point of information.
I have a point of information about what happens in the intervening period between the existing code of conduct and this new bylaw being implemented. Very specifically, we know it's going to take some time, maybe it's a month, maybe it's a quarter, until we get the integrity commissioner in place. And yet, are we going to be adopting the new bylaws in the intervening period? So, for example, if there was a code of conduct complaint against a councillor now, we would consider, after we've approved this, it would anticipate an integrity commissioner, and since they're not in place, would it then go to the mayor? And then if it went to the mayor, would the previous provisions of being able to determine who the investigator was, for example, which are changed in the new bylaw, would those still be implemented? So I'm just a little concerned about the crossover as we move from one to the other.
Okay, that is very clear. Thank you, Councillor Hardwick. I'll just ask staff to come off of mute and answer question around transition over to this new policy.
Certainly, Jason Twa here. So the way it's structured would be that there would be a requirement to have an ad hoc integrity commissioner appointed to just deal with the complaint that was brought forward. So, and under the process, if it's a complaint against a member by another member, that would be the mayor appointing a integrity commissioner for the purposes of conducting an investigation on that single matter. If it's a complaint by the public or a staff member against a council member or an advisory board member, then it would be the city manager appointing a person to investigate that.
Just building on that, right now, if a complaint comes in and the mayor chooses an investigator or proposes as an investigator, both the complainant and the complainee have opportunity to agree or not agree to the identity and appointment of that investigator. How would that be impacted?
So that would no longer be the case under the bylaw. We found that was unworkable under the current code in terms of attempting to get mutual agreement between the parties. So the bylaw envisions a process whereby, depending on the circumstance, the mayor or the city manager would simply appoint the investigator.
Understood. So that brings me back to the point about the intervening period before the integrity commissioner is appointed. Would it be the mayor or an interim integrity commissioner that would make that determination?
It would be the mayor that would make the determination as to the individual who would conduct the investigation. It would be an ad hoc appointment for that investigation.
Okay, thank you.
Councillor Hardwick, you have 90 seconds to finish your remarks.
Thank you. I'm happy to see this happening. I think that the existing document has been fraught with problems, and so we're moving in the right direction. I expect there'll still be some growing pains, but in principle, I am supportive. Thank you.
Thank you very much. And next up, we have Councillor Dominato. You have 5 minutes. Please go ahead.
Thanks, Madam Chair. I'm going to start with a point of information through you to staff. It's just to clarify, as the report passes, then the staff will be bringing forward bylaw for enactment at a future meeting. What are the steps for council to take in conjunction with staff to move through the formal process of appointing integrity commissioner for 2 years? What does that look like in terms of steps and timelines?
So the recommendation in the council report is that council would direct the city manager to conduct a selection process once the bylaw is enacted, and that then a recommended candidate for integrity commissioner would be put forward for council's consideration. In terms of timing, clearly there's going to be a process that's going to have to go underway to locate an integrity commissioner and then have that put before council. So I suspect that would be, a potentially, at least a month process, if not slightly longer than that.
Okay, so yeah, I would think probably several months in terms of timing between the bylaws coming forward for enactment and then the process if the city manager's office is taking on the recruitment process. So probably more likely March, April.
Yeah, that's probably a fair estimate.
And so in the intervening time, then it would be, as you said earlier, is that leveraging the ad hoc provision within the new bylaws.
That's correct, yes.
Okay, I think that answers my questions. I don't know if there's still further amendments, so maybe I'll hold my comments until we see. Thanks.
I don't think there are, but you can hold your comments. It's your right to do so.
Thank you.
Point of privilege. Oh, there, I'm on the list.
Point of privilege, Councillor Genova?
Oh, you said there weren't further comments and I was on the list. Just wanted to make sure we weren't calling a vote on anything. Thank you.
No, we were talking about amendments, but I'll advance Mayor Stewart and we will continue on. Go ahead, Mayor.
Thanks so much. Thank you to staff for doing all this work. A sizable part of my election campaign in 2018 was to increase council ethics, and little did I know how messy the code of conduct was until I actually had to administer it. It has been, I think, a total nightmare, which has been, I think, the result of the old code has hurt reputations of people, councillors, unnecessarily, because of the uncertainty of the process. It hasn't really, I don't think, been a just process, no matter how hard we tried. That's not a comment on the lawyers that were hired to conduct these processes, but from reports getting lost in the mail to all kinds of stuff, it's been terrible. And then, of course, as an elected person yourself overseeing this, it's hard to explain to reporters how the whole thing works. So I do think this is a huge step forward. I do like that staff, the code of conduct for staff will be reviewed at a later time. So I kind of see this as part A of the exercise. We'll have part B coming forward. And then council, I did also promise a lobbyist registry. So that is going to be coming. We had one crack at that, had some good feedback from staff. We'll be coming back with another proposal to council, but I'm fully supportive of this. What I really like is the annual review too, with a very knowledgeable person, because provincial and federal laws change too, and then it would be good for us to be able to have more of a living document than a bad one that seems stuck in time. So very supportive. Thank you to staff for all the hard work here. And just so council knows that if we get stuck in the ad hoc situation, I would be, drawing from the pool of lawyers that are already familiar with this process, that have been okayed on previous occasions. So that's with the advice of staff, of course. But that, if just to reassure you that I want this to transition to the new process as quickly as possible, so I can get out of the middle of it, because it hasn't been good, and I think not a good process at all. And thanks to staff. So I'll be, of course, supporting this. Thank you.
Thank you very much, Mayor. On to Councillor Kirby-Yung for up to 5 minutes.
Yeah, thank you. I think this is a really important piece of work, and I appreciate the effort that staff have put into this, including the review of other jurisdictions. I think that there has been a consistent and a shared commitment to increase transparency and accountability by this council. And that's something that I think we heard loud and clear coming into this term, that there was a huge opportunity and a need, framing it positively, to rebuild trust in their civic government. And we have taken a number of steps to do that, as was referenced with the Auditor General, lobbyist registry, and passing of other motions. I do want to acknowledge and thank Councillor DiGenova for bringing this forward, because it stemmed from a motion, I think it was referenced in the report, that she had brought forward in 2019, I believe in October. And I think it's important work to signal that. I think it's important to have an arm's length third party investigating things of this nature in the political construct in which we operate. It is a definite improvement over what we have now. And it does provide additional transparency for the public, which is really what this should be about, and it's who we serve, because they will now see the published results of reports, whether or not there's found to be issues of concern, and where lines were crossed, or whether or not investigations were found to be unfounded. And it's equally important that both are communicated. So I'm happy to see the recommendation for a third-party integrity commissioner. I'm happy to see it taken out of the political office of the mayor. I think for everybody's benefit to have that third-party extension. And I think also that the need to shore this up also speaks to the fact that there is additional capability built in here for the integrity commissioner to attempt to identify if any complaints that are brought forward are in fact frivolous, and or resolve things informally before they proceed to a formal investigation. And I think that's really important, because if there's an actual serious breach, it should absolutely be investigated. However, sometimes it may not be a breach. It may be a frivolous complaint, and it costs the taxpayer money to investigate those. So I think this strikes a really good balance there, and I'm looking forward to putting this in place and having it come forward. And I appreciate the work that was done on it. And I'm happy to vote in support. Thank you.
Thank you, Councillor Kirby-Young. Next up, we have Councillor DiGenova for up to 5 minutes. Please go ahead.
Thanks so much. And I've just actually sent in an amendment just after hearing some of the comments, including the mayor's comments. And I really do appreciate the extra time and effort that it has taken for the mayor to oversee this process on top of the other daily responsibilities that the mayor's office has and that our mayor has. That being said, in looking at this policy, considering the previous policy or the policy that we currently have has existed over many, many terms, we're not just looking at this for ourselves, we're looking at it for councils of the future. And just in trying to, really consider the integrity commissioner, the absence of an integrity commissioner, the fact that decisions need to be made, and it's not a process we want to hurry through. We want to make sure that we're listening to our staff, that we're making sure that we're doing this in the spirit of how this report and the recommendations have come to us and the reasons as to why we need this to evolve. That being said, the amendment that I put forward is that council delegate the appointment of the ad hoc commissioner to the city manager in all cases in the absence of an appointment of an integrity commissioner. And I don't know if the mayor meant it literally when he said, it's been a tough work. I think he's done an excellent job, but I also think that, the role of the mayor and the role of all council members, and it does include council members, is political. This also would apply, as it states on page 4 of the report, to staff, but this is also members of the public who file complaints. Right now, we have to agree on an investigator as council members. But that being said, again, not just looking at this for this council, as a council in the future. And on page 4 of the report, this individual will just choose the investigator. And I think I've stated the reasons, but happy through points of information through the chair to answer any questions that there may be on this amendment, but just wanted to share the spirit in which I was putting this forward. Thank you.
Councillor DiGenova, I do appreciate that. I'm going to stop your timer just to clarify the wording of the amendment. In that it reads that council delegate the appointment of the ad hoc commissioner. Do you mean the authority instead of appointment? But that just want to make sure the clerk has flagged that perhaps that word is meant to read authority.
Through you, if that would be best, I'm happy to send in an amendment to the amendment if I need to.
Okay, that's not necessary. We can change that for you. So I'll just ask the clerk to make that quick adjustment, and we can move over to an amendment.
It's just I had understood from law that I'm not sure if I could ask a point of information through you to law and staff.
Absolutely.
Appointment or authority would be the correct word.
Sure, please go ahead. That's over to staff. We've got the question. Is it best to read authority or appointment?
Jason, do you have a recommendation on that?
Yeah, I would think that we would probably want to say appointment, or yes, the appointment of an ad hoc integrity commissioner as opposed to authority. Okay,
great. So as it's been written by Councillor DiGenova, it stands. Thank you very much for the clarification. So we're in an amendment queue. Is there any discussion on the amendment? Mayor Stewart, please go ahead.
I think that because the staff component has been taken out of this and it's going to be in they're completely separated, then this would be fine. I think if that wasn't the case, this might present difficulty. But I'm okay with this, and again, it'd probably be the same pool of people that are chosen. So if I'm fine with this amendment if council wants to go ahead.
Okay, thanks very much. And over to Councillor Carr.
Yeah, thank you. Through you, if I could ask a point of information to staff. I'm just wondering if our legal staff could comment on whether or not this is okay from their point of view.
Sure. Let's have, if we can hear from legal.
I think the general direction's okay. I think that there may be some changes that we need to make to that section of the bylaw to more fully deal with that, because there are specific circumstances, for example, in section 5.6, that set out the circumstances in which an ad hoc integrity commissioner would be appointed. So the general direction, yes, but we may it may be useful for us to be able to draft that understanding into the bylaw.
And another point of information, does that require any amendment to this amendment?
The amendment is fine, but we would need to, like I say, we would need to address that expressly in the bylaw.
So you can do that without any change to this. Is that correct?
Yes, this general direction allows us to do that.
All I needed to hear was that legally this is fine. Thank you very much.
Okay, thank you very much, Councillor. Councillor Boyle.
Thanks. I also appreciate hearing that legally it's fine. It's not, it wasn't a gap to me in the work that staff did. So it's still not entirely clear to me that it's needed. And to just be upfront, we've been looking at this report for most of today. And so having not just seeing this very last minute and having not really been able to process it and not understanding the gap it's filling, that didn't stand out as a gap to me in the long time we've had to process this. I won't be supporting it. I just don't see that it's needed at this point.
Okay, thank you, Councillor Boyle. We are now going to go to a vote. There's nobody else on the queue, so please go ahead and vote on screen. And so let me just see here. That motion passes with Councillor Swanson, Councillor Hardwick, and Councillor Boyle in opposition. Okay, so we are back on the main queue, and I'll just actually take a moment. I think by the time we get through our final speakers here, and then we have to reconvene in council before 5 o'clock, unless council is agreeable to go to 5:15. We can start the meeting at after 6 o'clock at 6:15 in order to deal with one of the two motions that we have on deck after this item. So I just wanted to flag that as a, yes, please go ahead.
I just wanted to note that I will have to pick my child up at childcare and will not be able to stay past 5 p.m.
Past 5 o'clock. Okay. Let's go on to Councillor DiGenova. Do you have any final comments to this item?
I just really want to thank staff. I want to take a moment to thank all of our staff, to thank Mr. Mokri, the entire legal team, Jason Twa, everyone who's been involved in looking at the code of conduct. It's something that I know that although we may never find a perfect way forward, because there will always be a situation that perhaps doesn't specifically fit the model, I think that this is the very, very, very best, and certainly an improvement over the current process that I've found quite troubling myself. And I do think that we have to find a balance of having respectful discourse, but at the same time, make sure that people feel that they can, if need be, file a complaint. As we move into February, which we have, anti-bullying events and anti-bullying week, I think that it's really important with Pink Shirt Day and all of the other, there's other things that the code of conduct addresses. But I just think that it's a good reminder, and also something that this council can feel that they contributed to, that we all contributed to, and hopefully we can find ways to work through this in a way that we leave a legacy of an integrity commissioner here at the City of Vancouver that will serve other councils, because that is how I see it. And I meant it when I thanked the mayor. I think he's done a very good job, a tough job in having to oversee the process in the way he has and still be involved in the process. I still do feel that it's very important, though, that we do have an update to the process. And there are times that I've wished that the process was updated, that I have had to myself, consider entering into the process. And I have to say, the process that we currently have falls short considering the needs of council and the complaints that I have sort of overall knowledge through that the rest of council does as well. Knowing that it's a confidential process, I'm being very careful in what I say as well. So I just wanted to really thank staff for this. I know it's been a lot of work. I know you've been really thoughtful in your approach, and I know that these have been hard conversations to have. So that's all. I will be supporting this. I may ask for severing. I'm just going to look at the final document here. Thanks.
Okay. Thanks very much. Councillor Dominato.
Thanks, Chair. My closing comments will simply reflect is that I appreciate that council is having this discourse, particularly because sometimes our policies don't keep up with the times, and to the mayor's point earlier, the fact there will be a regular review, I think, is really critical. But I do want to start by thanking staff for the work that was put into this. There was an enormous amount of research, I think, that went into it. I know they leveraged some of the resources from UBCM, but I know they looked at other jurisdictions, and also appreciative of Councillor DiGenova identifying this as something that needed to be reviewed. And I actually think it shows a coming together of council that we've been making this work, and then ultimately we have a better code of conduct in place, both for this council but going forward. And I think that I don't envy the mayor. I think he inherited a very challenging policy that having these complaints having to be routed through his office. And so I think that what we've landed on is a much better code of conduct and complaint process, including the addition of an integrity commissioner, which I think will help bolster confidence, restore trust, and aligns very much with some of the other initiatives underway in terms of an independent auditor general from Councillor Hardwick, as well as looking at having a lobbyist registry from the mayor's motion, and all of these pieces will strengthen our democratic system, and I think that's really important for building trust with the public. And so I just want to reflect that, and also that not only we improve the process, but it's more transparent on a number of levels. And I think that's also critical to building trust and confidence in our system. So appreciative of the work and also all of the discourse that's taken place today around the table or virtual table here. So thank you, everyone.
Thank you, Councillor Dominato. And then we have here Councillor Hardwick, up to 5 minutes.
Thank you very much. So the code of conduct has been a very problematic document. I personally have dealt with it, as council knows, and I've seen it weaponized and used in very unconstructive and actually destructive ways. So I see this whole exercise as personally a great relief, that there will be greater integrity in the process, and that should give heart and the opportunity for more trust. Is it a perfect solution? No, it's not. There remain many concerns that I have about the manner in which we're dealing with code of conduct broadly within the city. There are conflict of interest aspects of it. Then other complexities that we're seeing, where I guess we're dealing with new things that changes in society, for example, that were certainly not contemplated in earlier documents. So,
Councillor Hardwick, I didn't indicate that you only had about a minute and a half left because your points of information at the beginning of this new session. So I just asked you to wrap up your comment.
I'm sorry, you said five. I thought you said 5 minutes. I'm happy to wind up my comments and say I'm grateful that this is moving forward, and I see it as a very positive move. Thank you.
Thank you so much, Councillor Hardwick. And Councillor Boyle, up to 5 minutes.
Thanks. Also grateful for the significant amount of work and thought that went into this, and particularly want to lift up the importance of the informal options, particularly for committees, and the alternative dispute resolution processes and the space created for less formal ways to wrestle through or respond to conflict, both for council, but also for those advisory committees where we have some very dedicated residents committing time. I think those changes have been put forward very thoughtfully. I think they'll make a significant difference in those spaces, and I'm grateful for the work that went into this.
Thank you very much, Councillor Boyle. And Councillor Swanson, please go ahead.
Yeah, I'm glad that
to be clear, you have 2 minutes.
I'm glad that this is being approved. I'm a little bit concerned, actually. While I agree with that we should be respectful, I'm concerned that if I say that Landlord BC, for example, is a lobby group, are some people going to say that that is not respectful? Or if I say that an investor who buys up apartment buildings and gets rid of tenants and raises the rent is a gentrifier, am I going to be accused of being disrespectful? So I think the question is not about being respectful, but about what is the definition of respectful. And I don't think we should let it be pushed over into statements that are political and made in good faith. But I'm glad that we're passing this. I think we desperately need it. And yeah, let's go. Let's do it.
Thank you very much, Councillor Swanson. So with that, and no one else on the queue, we are going to move to a vote. And I did hear that potential severing would be requested, so I just wanted to flag that to Councillor Pisanova. Not hearing.
I was looking through, and I'm not seeing the specific portion right now.
So no need to sever.
I'd like to move to sever. I don't know if we can. I think it's 2F. The component on the screen is listed as 2F from what we're seeing right now.
That's what I was looking for. Thanks.
Okay, so you're interested in
it says A2F, I believe, but it's difficult to follow because we just have the excerpts from the Folsom Code of Conduct. So that's the number I'm seeing on the screen.
Okay. So I'll just defer to the clerk quickly. Is it best so we can vote on the whole section and take out 2F and we can vote on that separately? If you can clarify, please.
It is the clerk here, Chair Bly, and yes, if that is council's will, that works.
Okay, so we're going to go ahead and vote on the on 2F, and then we'll vote on the balance of the recommendations. So I will ask clerks to go to vote.
And point of privilege, just for clarity, could you read out what we're voting on specifically?
We are
just to make sure
voting on the entire.
No, I understand. Could you read out 2F, just at least the first line, to make sure that we are voting on the correct piece, because I'm having the same issues as Councillor Kirby-Yung. It would have been helpful to maybe in future, I'll ask a point of privilege to have it emailed out, but I don't need that for one piece.
Okay, so 2F is responsibility. A member must respect and comply with the acts of the Parliament of Canada, the Legislature of British Columbia, including the Vancouver Charter, city bylaws, and applicable city policies, and avoid conduct that reasonably undermines or has the potential to undermine public confidence in city governance except members who participate in peaceful civil disobedience. And just to flag these, the entirety of the recommendations were emailed during the in-camera session. So we're in the middle of a vote, so we'll just ask everybody to continue to vote on screen. And clerks, I am in favor. And so that motion passes with Councillor DiGenova and Councillor Kirby-Yung in opposition. And then we will go to vote on the balance of the recommendations. And that passes unanimously with nobody in opposition. Thank you, Council. We that completes item 1, and unfortunately means we are not going to get to the 2 motions today that were on the agenda. And these motions will be deferred to the next committee meeting, which I believe is February 10th. So at this stage, we can adjourn the committee meeting for today and go into regular council, and I will pass the chair over to the mayor.
Oh yeah, I forgot about that part. Are we just recessing though? I think.
Just a pause. We're actually going to complete the business of this. I need a motion to refer the 2 motions to the committee meeting on February 10th. So if somebody doesn't mind doing that.
Sure, I'll move that.
Thank you, Mayor. And all those in favor?
Aye.
And any opposed? Okay, that's great. And so we are now adjourned in committee meeting and over to council and the mayor. Go ahead.
Okay, so I'm just looking, sorry, I'm just looking for this other script. It's, just give me 1 second, council, and I know we're at 5 to 5, so. There we go. I think I got it now. Okay, we're going to reconvene in council to deal with the recommendations and actions from today's standing committee on city finance and services meeting. Can we have the roll call, please, clerk?
Yes, Mayor Stewart in the chair. Councillor Carr.
Here.
Councillor DiGenova.
Present.
Councillor Fry.
Here.
Councillor Swanson.
Here.
Councillor Hardwick.
Present.
Councillor Wiebe is on leave of absence. Oh,
I'm back.
Okay. Councillor Boyle.
Present.
Councillor Dominato.
Present.
Councillor Bly.
Present.
Is in the chair. Councillor Kirby-Yung.
Present.
Sorry, Mayor Stewart, yes, the meeting has quorum.
Great, thanks very much. And if the clerks can help me here, we need a motion to adopt the standing committee's recommendations. I think it's just for items 1, isn't it?
So moved. Councillor DiGenova?
Yes.
Councillor Dominato.
Sure, I just want to double check that is it just item 1 we're moving on?
That is correct, Mayor Stewart.
Okay, thanks. So that's been moved and seconded. All those in favor, yay.
Yay.
Opposed, nay. Okay, thanks. That's carried unanimously. And now we need a motion to adjourn.
Motion to adjourn.
Motion.
Okay, thanks very much,
Second.
Councillor Harvard. I heard Councillor DeGenova seconded. So all in favor, yay.
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 Point of information?
Yeah.
Or I guess, is it?
Sorry, go ahead. We're kind of in the middle of a vote, but
yeah, I thought we were doing new business and.
Oh no, this is the meeting that follows the standing committee meeting at 6 o'clock. We'll be going in to do all that work.
Gotcha. Okay.
Okay. I didn't hear any nays. I'll call again though. Any nays? And that passes. Thanks so much.
Mayor, I have a point of parliamentary procedure. I think we also have to adopt items 2 and 3 that were passed on consent.
Clerks.
Mayor Stewart, the clerk is here. Just yes, we did do a referral motion for those two items. So that point of parliamentary procedure is well taken.
Move adoption.
Wait. So we just have recessed. So if you just give me so what we did pass was adopting item 1, and then we adjourned. So I'll come right back to you, Council. Okay, Council, I think we're okay that we, the intent was to move the items that were passed both through debate and on consent, as well as the referral. So we're good. And so enjoy your dinner, and we'll see you back in Council at 6. Thank you.
Welcome to TELUS Conferencing. To join the conference, enter your access code followed by the number sign.
Hi, Tina. Can you hear me?
Can you hear me?
Yes. Do you hear me?
Yes, I can.
Okay. Echo, Echo, Charlie.
Thank you.
Thank you too. Bye-bye.